Good morning, afternoon, and evening to all participants who are slowly joining in from all over the world. My name is Ivana Ninci-Zostala, and it is my pleasure to welcome you today on behalf of the International Mediation Institute, IMI, and the Mixed Mode Taskforce itself. This particularly so as these sessions are taking place in the first weeks into my new role as IMI Executive Director, although I have long been working with the Institute on the joint mission to advance mediation standards. The task force, comprised of over 100 international experts in arbitration, adjudication, conciliation, litigation, and mediation, academics and legal practitioners alike, has collaborated and worked diligently over the 5 years in a combined effort by the IMI, the College of Commercial Arbitrators, and the Straus Institute for Dispute Resolution, Pepperdine School of Law. The timeliness and importance of the work product that is being finalized is perhaps best described in the polling results of last week's session on the future of dispute resolution at the inaugural UNCITRAL Academy. Participants were asked, which factor do you think will most dramatically shape the international dispute resolution landscape in the next 5 years? And mixed mode dispute resolution with mediation as an element, and dispute system and process designed were answers given by an overwhelming majority. As Abraham Harold Maslow said, when the only tool you have is a hammer, you tend to treat everything like a nail. With the expansion of dispute resolution toolbox of lawyers and businesses to enabling innovative dispute resolution, the task force was created with the goal of developing practical suggestions for users and providers of dispute resolution services about how dispute resolution processes can be designed and combined to optimize the resolution of commercial disputes between businesses and what constraints should be considered. The work of this task force is therefore at the core of IMI's vision of professional mediation worldwide and mission of enabling mediation to grow through transparency and quality. Mixed Mode Taskforce is one of the task forces IMI has convened over the years as a platform for stakeholders to work together on important policy developments that will advance the development of dispute resolution. As a matter of housekeeping, please note that the meetings are being recorded. We will use the recordings to better understand or reflect your comments and questions in the final output of the task force, as well as for the visibility of the event. Regarding questions, we have envisaged the consultation sessions to be as interactive as possible. The co-chairs are here to hear you and your experience, so please kindly send us the questions in the chat box and we'll engage in hopefully in a lively discussion. Every session will additionally include polling questions from the task force's co-chairs designed to understand better the participants' practice and to initiate further discussions. The answers are submitted anonymously, so please do not fret. You may add your comments also in the chat box or signal to us that you would like to get the floor. We invite you to further familiarize yourself with the output of the task force, and including the draft practice guidelines and the summaries available in the series of articles on the IMI website. The public consultation sessions will be open until the end of September, and in the next 2 weeks, you may send us back additional feedback through a survey that will be circulated. Although there was much logic to how the working groups were set up, which will be talked about next, unfortunately, in putting together this event, we were constrained with the busy schedules of our co-chairs, which is why after the introductory note, we will be covering first working group 3, then 5, and then working group 2 and 7 after the break. We hope you will join us for the whole meeting, but we understand also if you have to come in and out as your schedules allow. I look forward to an engaging discussion and now hand over the floor to Mrs. Edna Sussman.
Great, thank you so much. So my name is Edna Sussman. I'm the co-chair of Working Group 4. I'm an arbitrator here in New York. I'm going to keep my remarks very short because Ivana did a fabulous job of setting us up with what this is all about. So I just want to say we are really thrilled to have all of you here. We are definitely looking for your input. I feel like perhaps we were prescient because, as Ivana pointed out, the Untitled poll suggested that this is what people want. And we started this project over 5 years ago. So we are glad that it's coming to fruition exactly when the world is very interested in exactly these kinds of developments in dispute resolution. So with that great introduction, I'm actually going to move right into having each of the working groups. There are 7 working groups. Each working group had 15 to 30 experts working with them to develop their product. And as Ivana said, I really do encourage you to look both at the short articles and the very long and very interesting reports. I think the project as a whole is fascinating in that it does go sort of from beginning to end of a dispute in terms of the different modalities that can be employed. And that is the way our 7 subgroups were set up, really to start with contract formation and going through, what happens at the end? Can the mediator speak with the arbitrator? So we're just going to take them in order in terms of the presentation now, but as Ivana said, the presentations in terms of in-depth discussions will not be in the same sequence. So if there are particular ones you're looking at and interested in, please look at the schedule and do those. So turning it over to working group number 1, and let's keep these really short because we do want feedback from the audience. So we're talking about less than 1 minute for each working group. Kathleen?
Hi, I'm Kathleen Paisley. I'm an arbitrator based in Europe and the United States. I was co-chair together with Jane Player of Working Group 1. The purpose of Working Group 1 was to look at the arrangements that parties can put in place pre-dispute, so in their agreements or in other mechanisms that are before any dispute arises. So primarily concerning how parties should put or think about putting clauses in their contracts, but also about ways parties should think about making contracts, making agreements, thinking ahead to dispute resolution at the time they are putting their agreements in place rather than after a dispute arises. Happy to be here.
Great. Working group 2, Laura, Jeremy? Laura, you're on mute.
Jeremy and I are delighted to be with you today. And our group was focused on if we're going to mix and match processes, both adjudicative processes and mediative and conciliatory and experts, how is that going to happen? So do you need someone to help you at the beginning of the process who can diagnose the kind of dispute that you're in and assess or recommend to the parties for their consideration different ways of combining processes, permutations, and considerations that will forward cost effectiveness and time effectiveness, especially of the process. So we look forward to you joining us later. Our session is after the break, early this afternoon.
Great. Working group 3, Veronique?
Thank you, Edna. Hi, my name is Veronique Fraser, and I'm a co-chair of Working Group 3 with Kun Fan from China. Working Group 3 is focused on mediators' use of evaluations and settlement proposals. So in some jurisdiction of the world, this is considered as a mixed mode, mixing evaluations. So evaluations and mixing facilitating techniques into one process called mediation. So we're looking into all of that in Working Group 3.
Great. And Working Group 4 is my working group with Klaus Berger, who was not able to participate today. But the idea with Working Group 4 is what can the arbitrator do staying within the role of being an arbitrator, not becoming a mediator in the more traditional sense. But what can they do using, for the most part, really established tools, many of which are underutilized, that really can facilitate settlement. We took a little foray into some of the psychology of what inhibits people from achieving a settlement and concluded that actually many of the measures that arbitrators take and can take, strictly speaking, in their role as an arbitrator, actually can have the same impact on the impediments, the settlement that a mediator can have, frankly. So we tried to give practical guidance on some established tools that arbitrators can take without running any risk of having their award vacated because they've stepped out of role. So moving on to Working Group 5, Moti and Tom. You're on mute, Moti.
I give Tom the floor, please.
Moti and I, Moti Moroni, professor and a great friend, and I are honored to be co-chairs of Working Group 5, which had the very interesting experience of working on situations where neutrals switch hats. A mediator is asked to arbitrate. An arbitrator is asked to mediate. It's a fascinating study because it's affected by culture and legal tradition. It also is confusing because we use different terminology and then we have different concepts of what mediators and arbitrators do. It overlaps a bit with Group 4, but nevertheless, I think ours is one of the most interesting, some of you might say one of the most frustrating aspects of mixed mode dispute resolution, but we're looking forward to talking to you today. Thank you.
Okay, Working Group 6, Kathleen.
Working Group 6, I was honored to work together with Jane Player again, the dynamic duo. We were looking in this case at how the potential enforcement of the result of the mixed mode process, how enforcement can impact the way a mixed mode process is developed. But also, it actually started out as a discussion of consent awards because, the view was taken by the group that people don't think enough about consent awards and how consent awards can and should be done and the impact that can have on dispute resolution in general, mixed mode dispute resolution in particular by an arbitrator. Then while we were on our way, the Singapore Convention was adopted. So we then looked again at creating a checklist for what mediators and their parties need to think about if they want their settlement to be enforceable under the Singapore Convention. But in addition to that, we looked at the bigger picture, which is to what extent does one need, or to what extent does enforceability create constraints, opportunities in developing mixed mode processes more generally.
Great. All right. And last but not least, number 7, Debbie and Dilyara.
Thank you very much, Edna. I was really thrilled to work with Dilyara, Dilyara. I know she knows that I understand who she is, and you all know who she is. Just wanted to preface this with when this initiative started, I was chair of the International Mediation Institute, and the concept for this initiative was an outgrowth of the Global Pound Conference that Jeremy Lack was very, very involved in. This great Working Group 7 really is looking at the future state and looking at whether arbitrators and mediators appointed to the same dispute can speak to each other, and if so, what are the parameters? It involves ethical constraints of people who are in both roles, and what level of involvement should the parties have in crafting the content and process for that communication. Should it be limited to procedural issues? Could it leak into substantive issues? What impact will that communication have on decision-making itself? So we had a lively discussion, but we want to hear from you to see whether this even is a concept that should be entertained, and if so, how? Thank you.
All right. Well, as you've heard, they are, I think, 7 very interesting and somewhat discrete and somewhat interrelated working groups. So we really, as we started out, we are really looking for input now. This is a public consultation. This will be a public document readily available as it is now and as it will be. We are planning to launch it at the end of November. So comments really are welcome between now and the end of September, and we really do invite you to participate. So I guess, to open it up a little bit, we're looking for input from people in the audience. Initial reactions to what you've heard. I guess raise hands and somebody can see it, or put your name in the chat.
Maybe we could start with one of our polling questions, which might get people loosened up a bit. We did create polling questions that related to the general topic as well as to the specific topics. And the first of those polling questions relates to the extent to which you as individuals recommend mixed processes when you're acting as counsel, either in-house or outside counsel, whether you recommend combined processes, including, for example, a stepped clause or having a DRB clause in a contract in addition to having, another form of dispute resolution. Could we maybe bring that polling question up and see what people say? Ivana, the first one?
I have launched.
Oh, super. I see it now.
Yes.
Sorry.
So the polling questions have been launched. There's 5 of them. I can read them out. How often do you use or recommend combined processes? And in practice, are you more likely to agree to a combined process in the contract after the dispute arises, but before the filing of a claim, after the claim is filed, but before a decision is reached, or never? Number 3, when a dispute arises, are you or your client more likely to be motivated to win, be proven right, resolve the dispute quickly as possible on fair terms, or other? Number 4, how could combining processes help you achieve that goal? And allow more control over the process, maintain the relationship, resolve the result faster, less costly, reach the better result, or other? And do you understand the term mixed mode, and do you think it conveys that what the task force is trying to achieve?
Right, so let's just start with the first question and see where the poll is on that and see if we can have some discussion about that result. So we have sometimes, I guess it's still coming in a little bit.
Yeah, it's still coming in. I can unofficially give you the results. So how often do you use or recommended combined processes? Sometimes. 13 out of 23 answered sometimes, and 6 out of 23 answered often. Only 2 answered always.
So turning to the audience or to the other people on the task force, what does that mean to you in practice? What is it that drives you to either recommend or not to recommend a mixed mode process in terms of what's actually happening in the case? Why would you not always do it, for example? Are there things that would drive you not to?
Abigail made a point in the chat. Abigail, I don't know if you want to make that point live or whether you just like me to make your comment on your behalf.
Are you talking to me?
Abigail.
Oh, sorry.
Abigail Penson.
On my behalf.
Okay. So Abigail made the point, which is something that I must say I hear often in my practice, because I actually always recommend, I'm in the always camp. I always pretty much insist, I kind of bully my clients or my business partners into step clauses. And what we hear often is, oh, that can be manipulated in order to delay the arbitration. And I wondered whether, other people in the audience or other people on the task force would have a reaction to that. The how one can avoid, to what extent is it a risk of a step clause that it be used to delay an arbitration, and to what extent can that be avoided? Do people have thoughts from the floor or from the panel?
Yeah, I mean, the ones I see, generally speaking, have a time limit. So I'm not sure I see the downside with a 30-day period, for example, if that's the appropriate amount of time, or 30 plus 30, if you can have executives first and then a mediation. That is very time limited. And I think often those can resolve the dispute or at least narrow that which needs to be pursued in a litigation or an arbitration. So I guess I would be in the always category, both in terms of contract drafting and in terms of what I do as an arbitrator and what I recommend. Tom?
Tom?
I start from the proposition that in nearly every commercial matter, you're going to have a mixed mode process, in the sense that you're probably going to, if you don't negotiate something right off the bat, and you begin an adjudication of some sort, you're probably going to be going back and forth between adjudication and negotiation. And certainly in the United States, it's pretty rare, in cases I'm aware of, that you don't have either litigation or arbitration combined with negotiation or mediation. So I think at its broadest, we're really talking about, a world of possibilities that are ubiquitous. And if you narrow it and look at arbitration and mediation, that's still a very broad categorization. But I think the beauty of our mixed mode task force is we're looking at many different kinds of scenarios where you have interplays between settlement-oriented activities and adjudication, primarily arbitration.
I mean, absolutely. I guess most people wouldn't think of just negotiation between the parties, because that's what one does before one brings an arbitration, as being a mixed mode. But if one thinks of it that way, then you're absolutely right. There's always one hopes, unless sometimes there's a surprise tactic. So in these IP cases, somewhere you just don't negotiate at all. You bring an arbitration and you ask for it. The last thing I wanted to say on this is, I do think that what I'm starting to see, which is I think a result of task forces like ours, is in the step clause, it expressly says that the mediation does not have to end before the arbitration begins. So it says you have to mediate for X number of days, but you don't have to stop, which I think is a step in that. I see another comment from Pierre. Pierre, do you want to do you want to make your comment or not? Well, maybe not. I mean, he's talking about the ICC survey. Okay. Oh, sorry. Go ahead, Pierre, please.
Sorry. Anyway,
go ahead.
The ICC just finished the survey, but the results are not available yet on pretty much the same topic. And one of the questions that was asked of ADR practitioners was whether the ADR track should be incorporated into the arbitration time track, or should be a separate track. And personally, I think it should be a separate track, so as to not delay the arbitration. And then they asked questions about whether the arbitrators should be made aware that there is an ADR process going on. And the people have different views on that. But one other point that I hope that this working group can also address at some point is, in my experience, the reticence about the use of mixed mode stems primarily from outside litigation counsel. And whereas in-house counsel want to have ADR as soon as possible. So I put that out as one question that I've faced in a number of situations, shall we say.
Great point. I think Tanya made the same point. Tanya, did you want to make your point live that you made in the chat?
Hi, everyone. No, I was just saying, I mean, I come from a jurisdiction where mixed mode is not that, a structured mixed mode, I should say, is not always the most popular option. And therefore, it's really for counsel and all those persons interested in dispute resolution to help show the way for the parties. As Pierre correctly said, outside counsel plays a large part in how often persons utilize the mixed mode method.
I think that's a point well taken. And I think part of the point of this whole exercise that we've been going through for 5 years was to make it more accessible, so people have literature they could read about it so they can understand it, and hopefully to make it also more acceptable as people begin to talk about it more, so they are less reluctant than they have been historically. You know, there's always a fear of the unknown. If it becomes more known, hopefully there'll be less fear and more buy-in, because it is often really a much better way to resolve a dispute in a way that is going to bring greatest satisfaction to the users.
Veronique, yeah, Veronique made a point in the chat on that.
Yeah, so in 2016, prior to the task force first conference in Pepperdine University, we had conducted a broad survey, and we wanted to see how much of mixed mode were actually used in the community. We knew they were talked a lot about in the literature, but we didn't know how much people had actually experienced with that. And what we discovered, I remember Tom and I, we were looking at the results, and we noticed that very few people had actual experience with it. It was within the range of 15% of the people we had surveyed. And today, when we look at the results of question 1, we see that it's much more different. We see that, for example, 57% of the people that are present today say that they recommend sometimes or use often, that they sometimes use or recommend mixed mode process. 26% say often, and 9% say always. So these numbers, even though the questions is asked a little bit differently, it just shows that it seems that mixed modes processes are used much more than they were 5 years ago. So that's interesting to know that they're gaining probably popularity.
Yeah. I think Jeremy wanted to ask a question, Mr. Lack.
You're on mute.
Sorry, Mr. Lack was my father. But Jeremy, the question I have for all of you, because I think we've got very clearly feedback saying that this is only sometimes used, is could I ask everybody to hypothesize, why do you think it's only used sometimes? What are your thoughts? If, you know, we're seeing that, you know, it's sometimes, but there's more traction. It's now been clearly identified both by CIDRA or UNCITRAL as the #1 topic for the future. ICC is now working on it. Why do you think we have such resistance, or if it's not resistance, a hurdle to overcome to encourage mixed mode? And maybe that's something we could discuss at this stage.
Great. I also think maybe as part of that discussion, Gabor, or maybe you want to make your point, because I think it might be related about the self-selection of this group.
Yes. Sorry. No, I don't think I can contribute. I'm really here to observe.
No problem.
I've been open to mixed mode practices through Jeremy, and I have to understand more about it in order to form an opinion. So I'm sorry, I won't be able to provide something meaningful here.
No problem. No problem. But I do think that is a valid point, which is obviously when you have a group of people who take time out of their busy schedules to join a meeting like this, there is some self-selection, of course. But I do think it's more than that, because the ICC, which is always, primarily an arbitration institute, has spent, one of their major topics right now is very similar to the topic that we addressed. So I think there are more people, perhaps partly related to COVID, where they see that it's driven by users. I think people are seeing that users are expecting their counsel and expecting their dispute providers to be more resolvers, as opposed to perhaps to being the gladiators that they may have expected, even a few years ago. At least that's my feeling. Do others have thoughts as to why there's not more, why there is more, what we could do to encourage it? I think the point about outside counsel is excellent. If outside counsel got on board, that would be, in my view, the single most important amplifier of our work. But again, they have to be educated. They have to see their interest in being in settlement. Thoughts?
The problem is that we're talking about these concepts in general across the whole world, across every industry. And I think that the information is not useful unless you know who's using it on an industry basis. And as most of you know, I'm very active in the construction industry, which has a long history of innovations, and especially with some of the concepts we're talking here with guided mediation and things like that. But just to talk in general about these choices, I think is not useful. I think it depends who you are, what industry you're in, what country you're in, and things like that.
I mean, I take your point. Obviously, construction leads the way in a lot of this. I would say I chaired in the ICC group, I chaired the in-house counsel forum, which was sometimes 200 in-house counsel talking about these issues, and only a fraction of which were from the construction industry. And there did seem to be a general view that the move away from arbitrators and their counsel seeing themselves as gladiators and arbitrators seeing themselves solely as decision makers, that trend, they were moving away from that trend. The question is how and how much. But I take your point. It's obviously valid. Construction's the one who taught us all of this, right?
But construction is a laboratory that I think that a lot of these ideas can be used in industries that are interested. Technology is interested in these things. Healthcare is interested in these things.
Yeah.
And I think the best way to implement these ideas is to find industries that are interested because they are very concerned about expense and time and things like that, and stop trying to take these concepts and just throw them all over the world and assume that people are just going to see the logic and just pick them up and run with them. That's not the way it's going to happen.
Point well taken.
Yeah.
Ferda, did you want to make your point about Turkey?
Hi, thank you. In Turkey, the history of mediation is very new, and the government mostly promotes mandatory mediation because of the caseloads. So we have to at first teach or inform the users about the other options. And now, due to mandatory mediation, some of the industries are much more aware about the mediation cases, and now they try to put new, let's say, clauses about mixed mode mediation arbitration. And now in Istanbul, the government promote İSTAK. İSTAK means Istanbul Arbitration Center. There, they also want to promote our first mediation, then arbitration, but still, most of the people are not aware of the other options. So, but due to my experience, I have, let's say, voluntarily mediation clients. I suggest them at first in the contracts and during the negotiation period. And I see it helpful. Thank you.
Thank you.
Nigel, you had your hand up. Did you want to say something?
Yeah, sure. I think it's good. I think Jeremy's point is well taken. We may be speaking to the converted here in terms of a lot of practitioners in alternative dispute resolution. When we're talking about the users and the legal community in particular, there's that aspect of risk management, and it may be fear of the unknown. And as a result of these sort of working groups, I think you're going to get some thoughtful production and appropriate dissemination out there into the community about, you know, step clauses, et cetera, because it's very difficult at a practice level for individual practitioners. Maybe managers might be more readily acceptable in terms of changing the firm precedents and things like that. But you're kind of pushing uphill here. And once again, getting these very practice-oriented tools out to the larger communities and having it become more common stream as our numbers are going up all the time in terms of exposure. I'm still not sure that we've got the real instruments and precedents that are going to make a real difference at a practice level.
I'm going to turn over to Edna, but I just wanted to say that, Pierre, you know, you made this point about recommending that mixed mode should be the default mode in rules, and I'm sure you know that the AAA ICDR took your advice, and in the most recent set of rules, you are required to start a mediation in parallel to the arbitration unless you opt out. So there is an opt out, but the presumption is there will be a parallel mediation, which is, I think, at least as far as I'm aware of, the first arbitration rules that require that as part of their rules, which is, I thought was interesting.
Well, on the domestic side, actually, that's been there since 2013. And so
Yeah.
they've done a little bit of a study to see, you know, to what extent it really has increased the amount of mediation, or to what extent have people opted out, given that is an option. And I think it has increased it, but at least in the early days, they didn't think it increased it as much as they had expected. They were getting a lot of opt-outs, but I think that is diminishing over time, because I think people, you know, are more and more accustomed to mediating. And it's been in the US for a long time, and I think it will spread all over the world, especially with the Singapore Convention now being in place and attempting, and I think will over time change the paradigm. So, you know, we have a few more polling questions. Maybe, yeah, okay, somebody who's, is that Paul? You've got your hand really, really up.
Yeah, just quickly, this is fundamental. We are trying to market and sell new ideas, and we don't talk like marketing or salespeople. At least in the construction industry, we are talking like marketing and salespeople. And to make a humorous point, I think our hero should be Jeff Bezos, that you need to take a look at the fundamental problems. What are the needs of the users of dispute resolution, and how do you satisfy those needs? I've never heard this discussion formally within these task forces. Everything, we're talking like a bunch of lawyers. We talk academically, and we need to talk like marketing and salespeople.
Yeah, and I think spreading the word. I think, you know, Tanya from Turkey is really an example of people who are trying to push the envelope in their jurisdictions. And that, I think, is really what we're looking for all over the world. And we will add marketing to our toolkit here. So let's take the next polling questions, because we did want to get responses to them. So Ivana, could you put up the next one, please, number 2?
I think most people have done all of them, but let's put them back up so they can finish if they didn't. Yeah, let's see the results. Absolutely. And if you haven't done them, please do them.
If I may just chime in about the situation in Serbia is exactly the same as in Turkey, except for the fact that we have yet to introduce a law that makes an opt-out of mediation mandatory. And the reasons why it's not possible, or it has not been possible to replicate the, let's say, Italian model or Turkish model, where in litigation for certain cases, lawyers and parties have to try mediation, at least one session, is because of the lawyers in Serbia. And the main argument is it infringes on the voluntary nature of mediation. So they see it in the most broadest sense of the word, on one hand, and also the arbitration practitioners, on the other hand, look at it as the little sister that should never be brought to the party, let's say. So they even smirk at the thought of initiating in parallel a mediation when they conduct arbitration, while in litigation, which is very protracted, and again, the same reason is given. Opt-in is not an option.
All right, we have to end this session to make time for the next one. We're going to keep strictly to the schedule. So maybe just show the results of the poll real quick. We have 2 minutes. Just so we
just a minute for
we do have a 15-minute break, I think, now.
No. The next
later. That's later.
The next is Working Group 3.
Oh, great. Okay, so we turn right over to Working Group 3. Are you guys ready?
Yeah, I think we're ready. I just wanted to highlight one question at the end of this survey. One of the questions we are asking ourselves is what to call this. We've been using the vocabulary of mixed modes. So far, 83% of you seem to think that covers what we're trying to convey, but 17% of you do not. So could we address the 17% of you in the chats? What do you think are better ways to describe what we are doing? We're really trying to get as much feedback as we can through the chats as well. So when you hear something being discussed and you have a thought, we're going to go back over all of this. We're going to look at the comments as well. So just because you're not speaking, it doesn't mean you shouldn't. We don't want your feedback. We do want it in the chats as well. And especially personally, where I think we're interested as a panel on what can we use as a better vocabulary if mixed modes is confusing?
Good. Thank you, Jeremy. Good contribution. That is something that we have been.
Could we put the polls back up so that people could answer the rest? Sorry.
I think they're up the whole time, but I think we need to reinitiate them.
Okay.
Ivana, do you want to do that? I'll do a stop sharing and we can share the results now. I'm not sure. Did they come up again for everybody?
I think people still wanted to answer them, Jeremy. That was my point. People are saying they haven't answered them all because they didn't see them.
Okay, quick.
So we just need to close it and relaunch it. But then we might lose the votes we already have.
It's okay. It's fine.
Okay, but we have them, and we know these are not empirically accurate, but there will be the survey afterwards, and some of these questions will repeat in the survey. So hopefully we'll have higher votes on this, and you'll be able to think about it between now and then.
All right. Anyway, so thank you all for participating in this session, and we invite you to stay on for all the succeeding sessions. And we're going to turn it over now to Working Group 3.
Thank you.
Thank you. Thank you, Anna. I'm going to share my screen. So hi, welcome already to the session of Working Group 3 regarding practice guidelines for mediators' use of non-binding evaluations and settlement proposals. My name is Veronique Fraser, and I'm going to be co-chairing this session with Jeremy Lack, who's an active member of Working Group 3. You want to say hi, Jeremy?
Hello, everybody.
So just for quick information, Working Group 3 is composed of 13 members in addition to the 2 chairs. So I'm chairing this group with Kun Fan. So part of the Working Group 3 members are Kenny Aina, Shella Alice, Barry Blendel, Rima Fawaz Elassen, Vivian Gu, Howard Herman, Cedro Untotegbe, Jeremy Lack, Christopher Lau, Paul Mason, Joseph Tirado, Jawad Sarwana, and Manan Shanwil. And in preparation to this consultation session, like you know, we have produced 2 draft reports. We have produced first a short paper containing an executive summary of Working Group 3's recommendation and a full detailed report. If it's useful, I will copy this link to this chat.
I'll
are you able? Oh, you'll be able to copy it? Okay, that would be great.
Actually,
so you can look.
Oh, I'm going to try to. Go ahead.
So if you need to refer to the summary draft as we're talking, you'll have it, the short paper. And we thought before beginning this session that it could be a good idea to do a quick poll to see how many of you have had the chance to read the material before this session. This will tell us just how much time we have to spend on presenting Working Group 3 as recommendations. So Jeremy, do you want to launch the poll?
I'm going to launch the poll if I can see it available. So yeah. I'm seeing the question, Working Group 3 introduction. No, I'm seeing the 3 questions. So I'm not seeing it in the polls. Maybe Ivana, can you help us? Where do we find the question of whether people have read the poll or the documentation or not? If Ivana is with us still. So I'm going to try and find it one more time. I'm sorry. Why don't you continue for the moment, and on that basis, and we'll go, and I'll try and look at it. I'll do one more time.
That sounds good. Thank you, Jeremy. So I'll start presenting Working Group 3's recommendations. So Working Group 3 has made a full report on mediators' use of evaluations and settlement proposals, but we've decided to come with 3 recommendations, 3 precise recommendations for users, neutrals and parties. The first recommendation is using Working Group 3 grid regarding party autonomy in mediation and conciliation process for process design. So this is what I'll present to you right now. So Working Group 3 considers that party autonomy or self-determination should provide guidance for reflecting upon mediators' use of non-binding evaluations and settlement proposals. So what we've proposed is using an adapted version of Riskin's, how we call it, new grid to anchor parties' autonomy in mediation. So if you look at the image on the screen, Working Group 3 grid consists of 2 intersecting continuums. The horizontal one, the horizontal axis represents party autonomy towards substance, or more specifically norm settings, and the concept of self-determination on the left and subjections on the right provides its anchor. The vertical axis deals with party autonomy regarding the process, and it runs from self-determination at the bottom to subjection at the top. So Working Group 3 suggests a shift from mediators' orientations to the effects of mediators' technique on party autonomy regarding the process. So all the grid that have been used in the past were focused on mediations intervention. So what are the type of interventions? What are the style of mediators? And instead we thought that this whole process should be focused on the parties. What do the parties want? And how much autonomy and self-determination they want to retain regarding the process and the substance. So it's a small shift of the grid that we all know, Riskin's grid that we all use regarding the process and the substance, but instead there's a shift and it's presented in the party's perspective. So this is the main difference that we created with this shift. And it's focused on self-determination and autonomy instead of being focus on the style of mediators' intervention. So what we wanted to highlight specifically is that when mediators use non-binding evaluations or make settlement proposals, for example, they exercise a norm-setting role by telling the law applicable, by evaluating the strengths of the parties, for example. So they exercise a norm-setting role, which affects to a varying degree the substance of the outcome or the outcome of the dispute. So what we say is that the party subjects themselves to the norm-setting authority of the mediator. And when norm setting is reserved to the parties, on the other hand, the mediator helps them identify the norms, whether they're legal, ethical, industrial, etc., that will be used to arrive at the outcome. So in such cases, we would say that parties retain full determination regarding norm settings and the substance of this dispute. So as you can see, the grid has 4 quadrants. So there's A at the bottom left, B on the top, C at the bottom right, and D at the top right. Quadrant A on the bottom left represents a process where parties retain self-determination regarding the process and the substance. Quadrant B on top is a process where parties retain self-determination regarding the substance, but they subject themselves to the mediator's control of the process. In quadrant C, parties retain self-determination on the process, but subjects their norm settings authority to the mediator. And finally, in quadrant D, parties both subject themselves to the mediator's control over the process and substance, controls over the substance. So if we want to simplify this presentation in terms that we all know, what we could say is that on the bottom left of this figure, we would find a style of mediation that Riskin referred to as elicitative mediation, where the mediator uses elicitive techniques to get the party's interest, to discover the party's interest, and lead them into a resolution. On the top right, we could call it directive mediation, where the mediator is still focused on parties' interests, but has a more directive style over the mediation. The mediator might ask more leading questions. He might direct the process a little bit more. He may call for caucus break and etc. On the bottom C, this is where the mediator will be evaluated. So using non-binding evaluations regarding the party's case, making settlement proposal, and there's a range, obviously, of evaluations. So we call it evaluative mediation here, or in some jurisdictions, they make a clear distinction between mediation and conciliation. Switzerland is an example of that. We find it to some extent in Japan, in Brazil, and in India, according to our research, where there's a big distinction between conciliation and mediation. So according to this diagram, mediation would be on the left side and conciliation would be on the right side. But we are also using the word evaluative mediation because there's not a clear consensus on this matter. So we're not making a formal recommendation to distinguish the two terms. And on the top right, we find a process where the parties are subjecting the process and the substance to the neutral authority. So this is a process like litigation and arbitration, and also some type of conciliation and evaluative mediation, where you really want a neutral to evaluate what is the strength, weaknesses of the case, and really lead the party towards a settlement in a very directive manner. Jeremy, do you have anything you'd like to add?
I just want to add something on this, which is I think it's really important, especially through the Singapore Convention, to understand that different countries actually in their trainings and their cultures very often tend to train mediation in different parts of these quadrants. So in some countries, if I take Austria, for example, as one extreme, there's a great belief in elicitative mediation in part of the training. The idea is that the mediator should never, ever make any proposals on settlement, and that they are purely there to offer options and discuss the process itself so that the parties have full determination on both the process and the outcome. So it's forbidden to make a proposal, for example, in Austria, and it's forbidden to make a mediator's proposal. In other countries, and I'll give experience I've seen sometimes with retired judges, and that can be in different jurisdictions. Very often retired judges are very used to working in quadrant D, because for them, even though it's non-binding, they still think the reason I'm here is to give efficiency so people can understand what is likely to happen in a courtroom if I were still a judge today. And so they'll still direct it both procedurally and substantively as though they would a court. And some lawyers, by the way, encourage it and like it because they like it. And in some countries, if I go to Turkey, for an example, where if I'm not mistaken, you need to be a lawyer to be a mediator, there is a danger that the culture of mediation might shift to be a conciliation type process, using the Swiss terminology, more than a non-evaluative mediation process. So I think it's important, and just to answer, Gabo, one of your questions, the real issue here, whether on the right-hand side of the grid or the left-hand side of the grid, is that on the right-hand side of the grid, you are, as a neutral, making recommendations on what you think the norms provide. So you are saying, an outcome according to law, for example, or industry standards are somewhere in this zone of possible agreement. And so you'll help people identify the zone in which an outcome should be done based on applying norms. Whereas if on the left side of this, you have no norms to apply on substantive grounds. So that's one of the differences between where mediator can be non-binding but still be evaluative. However, and this is one of, I think, the great things of your committee, Veronique, is that you've gone a step further in this. And I think that's where the self-determination goes. So I suggest you move on to your next recommendation.
Thank you so much, Jeremy. And just for everybody's information, I copied the link in the chat to the executive summary. If you want to download it, you'll have the copy of this figure and also the table that we're going to present next. So there was a question, what do we mean by non-binding evaluations versus binding evaluations? So it is true that usually only arbitrators will do binding evaluations, but because we're in a task force about mixed modes, we are finding all kinds of different design in the process. So the parties in mediation could agree that they want a binding evaluation of the mediator. It could be on a specific point that will help them resolve the dispute. So that's why we're talking about non-binding evaluations here, but we can see in some process where parties would want a binding evaluations, and this is covered in working group 2. The second recommendation is adapting neutrals techniques to parties' process choices regarding process substance and autonomy. What we've created with the grid that you saw is what we call the new ZOPE, so that we call the zone of permitted evaluation. So what we want to encourage is for neutrals to sit with the parties and really discuss what type of process the parties want. What is the degree of self-determination that the parties want to retain regarding the process and the substance? And for that, we've created a guide for neutrals mainly, where we've tried to recense a broad range of techniques that are used by mediators and conciliators. And we've tried to classify them into the 4 quadrants that you see on the horizontal axis. So you have the 4 quadrants, and we want to exemplify what kind of interventions a mediator will make if he's in the different quadrants. And we understand that during a process, mediator intervention can move in a different quadrant, that this is not, it's rarely that you'll stay in just one quadrant for the whole process. But what is important is to discuss with the parties in advance what you're going to do. You may start with one quadrant, for example, quadrant C, because the parties want a fast process. They want the mediator's opinion on a legal issue, but finally the mediator will discover that there's a lot of emotional and relations issues to be addressed and move to quadrant A, for example. So you can move during a mediation in the range. So this table is not to fixate the mediator's intervention, but it's just to understand what do we do in each quadrant. So I won't have time, obviously, to present this whole table, and you have that in the executive summary, but I'll present just 2 examples, the 2 extremes I'll present quadrant A and quadrant D. So quadrant A, which is full self-determination regarding process and substance, and quadrant D, one example where it's process and substance subjections. So for example, we all use questions, but in quadrant A, we will be using more open-ended questions and eliciting techniques, whereas in quadrant D, we will be using close-ended, suggestive, and leading questions. This is just one example, but you can read the table as I'm talking. Another type of techniques that we find mediators use and conciliators is educating, generating, and enunciating rules and norms. In quadrant A, this role is very subtle, where the mediators will be assisting the parties in generating their own criteria. Whereas in quadrant D, the neutral will actually be expected to set, educate, and advocate norms, whether they are legal, technical, financial, by which the dispute can be resolved. A third technique is assessment and opinions. In quadrant A, the neutral will not give any opinion on substantive issue, whereas in quadrant D, the neutral forms his own views on the matter and can apply norms. Finding of facts, for example, help the parties to understand the strengths and weaknesses of their case, exchange relevant information. Another type of technique is developing proposals. In quadrant A, the neutral will help the parties to exchange information and to brainstorm and to focus on their interests rather than their position, and to be able to create and put forth some proposal. Whereas in quadrant D, that might be the neutral that will be identifying dispositive issues or making a non-binding proposal for part of the dispute or for a range of the zone of possible agreement. The fifth technique is predictions. So in quadrant A, the neutral will not make prediction, whereas in quadrant D, the neutrals will provide his own opinion on the merits and predict the outcomes, for example, of litigation or arbitration. And finally, the last type of techniques that we've covered in this table is pressing or persuading, that we do not find in quadrant A, but in quadrant D, depending on, it's always a range of evaluations, but we can find a neutral urging the parties to focus on specific issues, urging the parties to settle, making threat to end mediation and move to mediation, etc. Jeremy, you want to add a few roles about process design or how you move from one quadrant to another?
Well, I think the issue that really will come up is, and we'll come back to that maybe at the end, is what happens when two parties have voted or want to be in a different quadrant. And how do you deal with differences when one party says, I want to be an A, and the other one says, no, but I want a D. I want a retired judge who's going to really direct, and we'll have a real discussion on norms and see what the zone of possible agreement would be in court. Another says, well, I'm coming from an Austrian tradition. That's not at all what mediation means to me. And I think that we need to, first of all, help the parties and their counsel identify that there's a cultural difference in cross-border cases, and then mediate that in and of itself. Does that mean we appoint two co-mediators? We'll have a judge who's used to style D, and we'll appoint an Austrian mediator, and the two of them will co-mediate and use their two different things. Is that one way? Or do we simply move around and say, we'll start with the Austrian mediator, we'll ask the judge, are you comfortable being an A and D, and can you maybe start at 8 o'clock in the morning in A, and at 5 o'clock in the evening, if we don't have an outcome, then you move us to style D. I think the issue is knowing where you are at and how to move forward. But I think for me, the most exciting thing, again, is what you've done, Veronique, with the team is the whole ZOPE concept, which I know, you've touched on in some of these questions, because you are really, I think, for the first time saying to the neutral, stop. Before you make a proposal, make sure that you are acting in the zone of permitted evaluation. Maybe this is not the field that they want your expertise in. So if somebody comes along and says, he acted in bad faith as a bad partner, but my expertise is on causation, on, mechanical issues, nobody wants to know your views on what is a good partner and are they behaving fairly or not. Are they asking to provide your sense of equity coming from the culture you are in? I had a case in arbitration, I remember, where a case was lost because a client said to the tribunal that he thought that something was morally binding and not legally binding. Now, in the client's eyes, morally binding is far more important than legally binding because you have to do it. But in the eyes of the tribunal, when they gave their judgment, said he thought it was only morally binding, not legally binding. So the judge assumed that legally binding was less important, that morally binding was less important than legally binding. So, you know, these are the areas where sometimes that adjudicative input of what did a person mean and what do I decide based on it is outside the zone of permitted evaluation. And I love the concept that we need to be more circumspect as neutrals to make sure that we are operating in the zone we've been permitted to provide evaluative feedback.
Thank you, Jeremy. We're going to move to the last recommendations, and then we're going to open the floor for polling and then your comments. So the last recommendation is we've created a checklist of elements to consider when making evaluations. So this list is substantial. This list appears in the final report and not in the executive summary. It's in the appendix, just for your information. But we wanted to create a tools for neutral if they want to help the parties decide are evaluations appropriate for this case. So we have a broad range of questions that we can ask and consider. For example, what's the type of the dispute? Is it a construction dispute, family dispute, partnership dispute? What is the party's background and resources? Do the parties have access to their own, for example, counsel and legal advice? What are the parties' past relationships? Do evaluative techniques can have the potential negative effects on parties' perceptions and the relationship? Because we're going to bring the discussion to a more competitive style of discussion. What are the parties' cultural preferences? What are the parties' process goals and values? Do they want a very executive mediation, or do they have time to address some broader relationship issues? Is there risk of coalition building or increasing adversarial process if you start to evaluate too quickly? Are there some face-keeping or protection measures to consider? Will the impartiality of the third party neutral be compromised? And this is one important question, and it regards process design. If the parties know in advance and have authorized the neutral to evaluate, then there is less impact regarding the appearance of impartiality of the neutral. But if it's done without consulting the parties beforehand, then that might surprise some of the parties that didn't expect that would be the role of a mediator. What is the timing of obtaining the parties' informed consent regarding evaluations? Does the mediator need to explain the possible consequences of using evaluative feedback on, for example, the risk of coalition building, conflict escalation? How to organize and receive feedback to procedural proposal? Should non-binding evaluations or proposal be made in joint session or first tested in caucus? So we have a broad range of questions, 17 questions that you can check with the parties. We can, yes, go ahead, Jeremy.
So I was going to say, I've been monitoring the chats, and we already have some original feedback from Carl Bayer. And Carl, I would just invite you to take the microphone and maybe share the comment you posted, and we can maybe discuss that. And we encourage everybody else to provide comments again by chat, but also feel free to pick up the mic and speak. So Carl, if I could invite you to be one of our first responders, please.
Thank you, Jeremy. I appreciate the grid. It's helpful in my own analytical thinking, and the checklist is wonderful that somebody gives me something to go through. I admire the attempt to talk about it from the party's perspective, because that is what we really ultimately are all about. The difficulty I find in practice is, through no one's fault, who's the party? Let's think about, in a major company, is it the general counsel? Is it the head of marketing? Is it the CEO? Is it the COO? Is it a combination of all of them? Getting the parties' wishes sounds easy to do, but I'm not ever sure exactly until I get into the mediation a little further who's the party. And then oftentimes it still doesn't remain clear. That's one comment I have. The second, and it's related, is the cultural differences that you mentioned, and you said cross international borders. I would suggest that even within a purely domestic company, my experience these days is there are many cultural differences, at least in the US, driven primarily by age. Huge difference in the culture of people in their mid-70s, such as me, versus a Gen Zer, a Gen Xer, a millennial, whatever. So the cultural issues are there even if you don't have an international border. The third comment, and then I'll give it back to you, has to do with the evaluative approach. Really, I make a good number of mediative proposals in mediations that I do, because the parties seem to want that at the end. And what I'm really evaluating, frankly, doesn't have much to do with the law, the facts, the culture. It's me choosing a number or a proposal that I think will work, that will stretch both sides to the limit. And so I guess some people might say that's evaluative, but I have a very large preface before I'm willing to embark on that I'm not evaluating the case in terms of legal success. And so that what I find that I'm really evaluating is what will actually be accepted by both sides. And I guess it's a combination of the 17 checklists plus a bunch of intuition plus things I've learned during the mediation itself.
Can I ask you, do you ever do intake meetings before you go into that first joint session? Because
I insist on it, Jeremy, and unfortunately many people don't do that, but particularly with the Zoom practice and the ease of now scheduling things, I've really tried to encourage people to spend small chunks of time before we actually show up all together. So I don't talk about a mediation day anymore. I talk about a mediation month. And instead you have many series of 1 hour sessions. And if people will buy into that, it's very helpful in helping them design the process that they really want.
But address that confusion of what does the CEO want, what does the head of sales want, what does the general counsel want, et cetera. Would an intake meeting to maybe go through even this quadrant and ask them, let's have a discussion. What do you actually want as a corporation? What do you want amongst yourselves? Is that something you would do in one of those preparatory sessions, or it's not something you feel would be appropriate?
No, absolutely. And I would prefer, once again, I respect the role of outside counsel. I respect the role of general counsel. It makes it very difficult for me, a total stranger to the dispute, to immediately win the confidence of the parties where I can actually talk to the head of marketing without the general counsel present, without the external trial lawyer present. They necessarily don't want me to do that almost in their role. Eventually, if I can win their trust and have those kind of conversations beforehand, Jeremy, it really does help. It's tremendous. You really do get a feel for but the key gatekeepers there are the general counsel and the outside trial counsel, and but just their mere presence in the discussion, I find changes the nature of what the individual employee or management or board member might want.
Thank you. Are there any kind of any different thoughts? Let me discuss. Pierre de Ravel,
Yes.
Descaplon, please go ahead.
Well, I'd like to sort of bring up a couple of points following what you, Jeremy, and what Carl has said. Number one, subsumed in all of the discussion is the key ingredient for mediation success, i.e. having the ultimate decision maker in the room, or not just available. And that goes to the discussion of, is that the head of marketing or whatever? And I can tell you that having been in-house counsel for some years, at one point in my career, the number of times I've seen disputes being shifted and being dragged along until the executive got moved and it was no longer a hit on his personal P&L is not insignificant. But to go back to what Carl was saying, I always have calls with the parties before the mediation as preparation, which is very important. And I asked them to send me a memorandum outlining what they see as the strengths and weaknesses of their case and of the opponent's case, just for my eyes. And that helps greatly in focusing attention. Anyway, that's what I wanted to say.
So Pierre, that's touching on something that's very important in of itself, because even the preparatory documents, if you ask for a position paper, what are the strengths and weaknesses of the case, are you to some extent priming them to think of an evaluative mediation? Are you thinking of them to think of the application of norms to the outcome that should shape the zone of possible agreement? And you're no longer focusing on there are things outside the zone of permitted evaluation that people should be limiting themselves to. And I think these are part of the questions on, should we be asking people before, what are your, don't give me your position paper, but give me your list of subjective interests looking to the future. Is that maybe a more useful approach for mediation preparing? I think there are a lot of issues, but before we continue with the questions, we did have a couple of polls for you, and we only have, again, I think 12 minutes left for this session. It's a bit rapid. So if you don't mind, what we'd like to do is ask you the polls first, and then with the time left, let's go back and I encourage you, put in the chats in the meantime all your comments, because we will definitely read through them all. But I'm now going to working group 3, and there are 2 different sets of questions, I understand. The first one is, so I'll just launch the first poll. The first one is, mediators or conciliators should discuss with the parties the use of mediators or conciliators evaluations at the outset of the process, whether they will be used or not, process timing, etc. Do you strongly agree, undecided, disagree, or strongly disagree? And please, there are many of you, there are 49 of you, so we'd like to see as many of you vote as possible. So I'm seeing the numbers creep up, but we're still at low numbers, only
Jeremy,
11 of you.
I have trouble understanding what question 2 relates to.
So let's move on to question 2. At the outset of the process, a mediator or conciliator should discuss with the parties the impact of its potential interventions on the self-determination of the parties. So in other words, if you are going to be saying, I'm going to be evaluative, are you removing from them a sense of self-determination? That's how I understand it. So when you say, I'm assuming from the outset that I'm going to be able to make a mediator's proposal, are you already affecting the concept of self-determination? Do you need to seek the permission to be able to make a proposal? Because I think if you look at the model law from the new model law and the old conciliation law of Untitral, it says that the mediator or the conciliator is entitled to make a mediator's proposal at any time. But is that somehow taking away from the concept of self-determination? You have the language on the screen here that addresses that issue. Because it says in Article 1.3 in the model law, this is not the convention, thank God, but it is important in the model law. It says mediation, conciliation, or any similar import. So it means kind of, we think it's all kind of the same. And because it's the same, because nobody has the authority to impose the solution on the parties, agreed. However, in 7.4, it says the mediator may, at any stage, make proposals. And that tends to be viewed as an evaluative input. And so do we need that ZOP? Do we need that zone of permitted evaluation? And that is, I think, going to be an interesting concept as we work more and more internationally. So I hope that that clarifies the question for you. We do have 80% of people online at this stage who participated. So if you have not finished in 30 seconds, we're going to have to close the voting on these two questions.
I think there's a problem for some of us voting. I can't vote. So
you can't vote because you're a co-panelist. Okay, those of us, see, you don't have the option. I'm sorry, Kathleen.
But then I'm happy not to vote, but then you have to take us out of your percentages. So
we do, because it only counts the people who can vote. So right now we are 48 people online, but only 40 people can vote. That means 8 of us cannot vote.
So did you not want voting on the third question yet? Because there's only been 2 questions.
Well, no, we don't have them, but they've been split into 2 groups. So I'm trying to get everybody's feedback on this. So we have 85% participation, and I'm going to say going once, going twice, going 3 times, and we're going to have to close the voting on these 2 questions. And let's share the results with you. You can see already that from the people who voted, and so now that's the new 100% is the 85% of who voted. There's a strong sense of agreement or agreement in any event, whether you combine them, of over 85% when you take them together. So overall, there is this belief that this should be discussed early on, although not everybody agrees strongly. Some agree more mildly. The strongly disagree and the disagree, however, is 9%. And that's important because that shows it's a cultural issue also for in some places where there'll be strong rejection of this, which is important to understand. The second question that we had at the outset, should discussions, will they have an impact? And there is a sense that there is likely to be a strong impact. Again, if you add strongly agree, we are above 70% there. But disagree or strongly disagree is also a bigger fraction here. So these are things that we'll need to think more about. I'll stop sharing these polls, and I believe that there is a second set of questions for group 3 around the grid. So let me launch these questions now. And we have a series of questions for you that are important for us. So please, all of you, do vote. You now know how to do it. We really would ask you to do it. It's really important for us in the feedback. To what extent do you find this new grid, which is based on this concept of self-determination versus subjection on both axes, to what extent is it useful, do you find it useful for assessing different forms of processes? Is it something that you find you might use or not at all useful? That's what we're really interested in finding out from you. Is it a useful diagnostic tool? So that's the first question. Then the second question that we have is, to what extent do you find this chart, well, it's the usefulness question. So I confused 1 and 2, sorry. So 1 is, to what extent, well, it is, they are the same question as I look at them. To what extent is it useful, and to what extent, oh no, this is the second question, is about the 6 techniques, I'm sorry. The 6 techniques are the chart. If you remember, there were questions as the first thing, as a way to look at how to approach it, the use of norms. Do you want to help people generate norms? Are you there simply to apply the norms, to advocate the norms yourself? Thank you, Veronique, for putting that in the background. It's this chart, this concept of by technique, by the 6 techniques, then looking at what might I want to do given that I've been asked to do this? Is that also helpful or not? That's the second question. And I think we only do have 2 questions on this poll as well. So I'm not sure what happened to the other 3 that we had, but they're not there. So so if we can ask you just to vote again here. And we're at 79% participation. So we just do want a few more of you to vote, because then we'd like to get above 85% this time if we can. So go on, 1 or 2 more people, that's all we need. And I'll say going, gone, because we want 5 more minutes to be able to close. So at 82%, I'm going to end the poll and then show you the results. So it's very good to see that while some of you are undecided, 13%, and there's 3% against it, overall, we're getting a very clear sense of this could be useful, but we see that it's only somewhat useful for the majority, not very useful. So let's think already about, if you can give us some ideas for those of you put somewhat useful, what could we do to make it more useful? How could we enhance this as a tool? It would be a topic for us. And to what extent do you find the new chart with the 6 different techniques useful or not? And there, again, I think we get something quite similar. In fact, it's almost the exact same breakdown, except we've got nobody against it. Nobody finds it not useful. So that's at least a slight improvement. But again, it would be helpful for us to know what could we do with these 6 techniques and how we look at them to make it even more useful, from somewhat useful to tip it more towards very useful. So again, in the 5 minutes that are left, or 3 minutes, because we do have tight time schedules, does anybody want to add some comments or kind of reactions to this session?
Can I say something?
Go ahead, Paul.
Yeah, the most important thing a mediator can do is diagnostics. That, and I agree with everything that Pierre and Carl said, that before any settlement negotiations start, before the mediation starts, there must be diagnosis. And if the diagnosis is that, and the diagnosis is confidentially done, so you find out that one party really wants an opinion, well, from the media or from somebody else. Well, when I have a situation like that, you know, I start a process going where we get a third party opinion, either binding or non-binding, you know, and that satisfies the need of the party that want an opinion. I, as the mediator, don't have to give that opinion. And other thing that Carl was also mentioning about these virtual sessions, one thing that has really changed mediation is the ability of the mediator to do a virtual, confidential diagnosis with each one of the parties. So it isn't like walking into the mediation, you know, and, you know, bingo, the first thing you start asking a question. You can do it confidentially, ex parte, and that is made in the construction industry. That has made a tremendous difference in being able to diagnose, and as Jeremy asked, and make these questions in these charts useful.
Thank you so much, Paul. Unfortunately, I'm looking at the time, and it's already the time to close the session, but we'll be very interested to have your opinion. So if you have any further comments, you can send them to Jeremy, to myself. I'm putting my email address here. And Koen will be back with us on Tuesday night. So it will be midnight in the East time, but she'll do another session on this topic. So please send us any comments. That would be very appreciated. Tell us also where you want this working group to, what would be useful to do. So we've had a lot of comments that the tools that we've developed are useful, but somewhat useful. So what can we do to make them more useful? What do you need? What kind of tools are needed to help you provide some process design with the parties? Because we've seen that this group has, a majority of this group find it important to use process design and to tell about the parties, what type of evaluation, what type of interventions you wish the mediator would do, and discuss the impact of the evaluations. And then we've tried to create some tools to assist the mediator to do that. But maybe where tools can be refined. So what kind of tools could we develop here? So we'll be very interested to have your feedback, and it's already time to move to the next session. Thank you so much, Jeremy, for co-chairing with me today. That was great. And we look forward to continuing this discussion with all of you.
Now it's on to Working Group 5. Neutral switching cats.
All right, can everyone see the slide that I put on the screen?
We can.
Yes, yes.
Okay, this is Tom Stepanowicz, and I'm very delighted to be working with so many wonderful people who have been part of Working Group 5. My co-chair is Professor Mordechai, also known as Moti Moroni. He's fondly known by my wife and me as Mixed Modi, but Modi and I have had a wonderful experience, again, working with so many people on, I think, one of the more challenging topics associated with this overall effort. And you see that we have a significant number of participants from all over the world. And it's been a wonderful ongoing conversation, and we're delighted to have you with us today. When we talk about switching hats, we're really describing scenarios where a mediator may at some point, under some circumstances, take on the role of arbitrator. This sometimes happens where mediation is unsuccessful, and the parties may come and suggest that the mediator take over the adjudicative role. Another possibility is where an arbitrator at some stage is invited to mediate. And in a number of cases, this may mean that the disputes that have been submitted to arbitration are successfully resolved through mediation. In such cases, it may be possible for the arbitrator turned mediator to resume the role of arbitrator and issue a consent arbitration award based on the settlement. Of course, if the mediation is unsuccessful, then you have the question of what happens next. In some cases, the parties' agreement may provide for the neutral to resume the arbitral role. This raises a number of the same issues that may be implicated in MED-ARB, where you have someone who has been engaged in mediation, perhaps with independent caucuses, individual ex parte discussions with individual parties. And this seems to be the primary area of concern for a switching of hats. We'll talk more about this now. When we look at this issue, it's really dominated by much of the discussion, particularly the academic discussion, has been dominated by concerns regarding switching roles. Issues relating to the fundamental incompatibility of a role in which you as a third party are facilitating a resolution of conflict, and other circumstances where you're serving as an adjudicator. So we have, first of all, some philosophical differences about exactly what's appropriate for a neutral to do. Should you ever switch from one role to the other? And there are quite a few neutrals that we all know who say, this is not for me. I'm not a switching hats kind of person. Likewise, there are lawyers who may say the very same thing, and this is heavily influenced by culture and legal tradition. There are also concerns about party autonomy. We described somewhere in our study situations where a neutral has put pressure on a party to be permitted to switch roles. Now, I can't say that anecdotally this happens often, but there's certainly some issues about the ability of parties to make determinations regarding this very critical juncture where someone is actually switching from one role to the other. There's also the issue of what happens if the parties and the council are aware of the fact that a mediator may be switching to an adjudicative role. And you often hear people say, well, people are going to be even less candid when they're talking to the mediator, it's going to reduce the ability to have interchange, and they'll be focused on spinning the mediator so that they can affect the eventual arbitration. There are also, and I think this is at the heart of concerns, due process issues. Concerns that ex parte communications in mediation, which cannot be addressed by the other party, might have an impact on a subsequent arbitral decision, and there would be no opportunity to contest or challenge or raise issues regarding whatever those communications were. Another area that our discussions have really highlighted, which I have not seen referenced before, is that there are sometimes expectations raised by things neutrals say during the course of mediation. They may create expectations about how they might function as an arbitrator. And we give an example or two of this kind of scenario. Then there's the issue, of course, that some neutrals simply do not have the capability or the orientation to be a good mediator. Perhaps they're very successful as an arbitrator, but can't really switch into that other role. And then there's concerns about lack of clarity regarding exactly where are you. If you're going to have a situation where you have someone wearing multiple hats, what hat are they wearing at a particular time? What is the process you're in at any given point in time? And what is the final result? This can raise issues relating to enforceability. Now, what makes this so interesting is that although some of us are drawn to this whole working group because we're concerned about these issues that I just raised, one of the things that we have seen, which is fascinating, is that even in countries like the United States, where there are a lot of due process kinds of concerns that are raised about mixed roles, we find that a substantial minority, between 40 and 50% of neutrals, probably switch hats at least occasionally. So it's important to keep in mind that there are neutrals who are doing this. Some have made it a part of their brand. And it is not, I think it's important to say at this point, this is not something that we are coming forward and saying is an all-purpose solution. We're really trying to deal with those special scenarios where, as a result of cultural inclinations or because of changed circumstances or special needs of parties, combined with a high degree of trust in a neutral, parties say, we want to do this. The problem is, given cultural differences, given maybe the lack of understanding about where the other parties are coming from, we recognize that caution is necessary. So there are a whole variety of reasons why you might switch hats. Prioritizing amicable resolution and societal harmony. That's the reason why in China you see this occur so often. Arbitrators and judges becoming mediators in the course of the process. Sometimes it's argued that by having a single neutral play both roles, you promote efficiency and economy. Also, the notion that it may be possible for a neutral with sufficient capability to help the parties improve relationships or maintain relationships to a greater extent. Another thing that I think is very significant to me is addressing special interests or changed circumstances of parties. An example, which we give in our report, is a recent one, where an arbitrator was engaged, who was a member of our working group, was actually engaged in arbitration. They had gone about halfway through the arbitration hearings and the pandemic hit. Nothing happened for 2 or 3 months. And then the parties came back to the arbitrator and said, we've got to have a result. We're negotiating. We need your help to arrive at a negotiated resolution. We trust you. You know a lot about our problem. We don't want to arbitrate. We want you to mediate. So that's an example of a scenario where special circumstances it may be appropriate for this kind of approach. It does indicate the importance of rapport and trust in a neutral third party. We also sometimes hear arguments like this kind of situation where you know your mediator is going to be an arbitrator. It provides the mediator with a big stick. Well, there are arguments both ways on that one. But of course, as we said before, it may help set the stage for a consent award in arbitration. Modi, before we go on and talk about our practice guidelines, let me ask, do you have other comments you would like to make?
Thank you, Tom. I just want to say I have a lot of experience with mixed mode, and I just want to add a few comments because I think your presentation was brilliant and really covered most of the things that we are talking about. First of all, we have to remember that a lot of people, when we say, oh, we are dealing with hybrid or we are dealing with mixed mode, and they ask, can you give us example? Usually this is the example. Arb-med, med-arb, arb-med-arb. This is usually associated with what we call mixed mode. And I think no wonder that maybe our working group was probably the largest, and the issue is very, very complicated. And I want to share something from my own experience. First of all, as you can see, something is missing here, and this is the why we use quite often, at least from my experience, why we use the mixed mode. First of all, because I find, and especially in international business dispute and also in sport dispute, people come and they need finality. They need finality. They cannot, mediation, not always we come to an agreement. And give you an example, some people come from abroad to Lausanne, to other places, to settle a dispute, and they are able to settle most of the issues. Two issues are left open. Now, should they go back? No. One way you can do is you propose, the mediator propose, or the parties may propose, let's switch head and let's arbitrate the two issues, okay? So this brings me to one of the issues that are very, very important in switching heads, and this is whether you do a switching heads arrangement, pre-dispute, or in the midst of the dispute resolution process, and it's a huge difference. And I think it's something that we shed some light on this issue, and I think it's something that we should consider. And this is not only important for the users, it's also very, very important for the neutral. Now, another need is we speak about consent award as if we need it primarily for enforceability. But I would like to say that sometimes organizations or companies may need the consent award, and it's not for enforcement, but they need it for some organizational concern. So especially when there is a large group of people, heterogeneous and so forth, and the delegation that comes to the mediation say, okay, we can agree, but we are going to have problems coming back home with what we call in the negotiation the second table, maybe with the board of directors, maybe with some groups of people who will be against the agreement. So please issue it as an arbitration award. So this can also be an important contribution of mixed mode.
Okay, well, thank you, Modi.
And the last point is that you have to remember that in a pre-dispute, it's a decision based on interest and what are our needs and so forth. While we do it in the middle of dispute, it's primarily hinges on the trust of the parties in the neutral. Because if the neutral has gained the trust of the parties, then it will be very easy and it's very likely that they can move from mediation to arbitration or vice versa. Can you please, Tom?
Okay, thank you so much. We want to have time for your comments and questions. And so what we'd like to do would be to very briefly touch on some of the practice guidelines that we have developed. And I'll take about the next 5 to 10 minutes to go through that. And then hopefully we can open up the floor to questions and perhaps have time for some polling. Let me just briefly go through some of the elements of the practice guidelines. I think one thing that you've already heard we say is very critical in mixed mode processes is mutual understanding. And that begins with understanding what do mediators do and what do arbitrators do. We've spent a considerable amount of time talking about what is within the realm of mediation. And we have a whole working group just looking at the role of evaluation in mediation. We also have another group that looks at arbitrators and their role in facilitating settlement. And this is something that many arbitrators have never even talked about. At the same time, we recognize that many of the things arbitrators do in the normal course of activities do have an impact on settlement. But these are the kinds of things we think parties should be talking about. And we mention that again in our guidelines. We also, as I telegraphed a bit earlier, we also think it's very important for parties to take the initiative and to have autonomy in making decisions. They should be able to make decisions outside the presence of the neutral and not have the neutral pressuring them to make a role switch. That said, it may be critical to have a conversation with the neutral about exactly what it means to switch hats, all of the details of the process. Very often, the neutral will have experiences that will be relevant. The neutral will be able to counsel the parties. I think, though, one key element of this is that at some point the parties need to address this outside the presence of the neutral and be able to ensure that no one is not buying into the process, because this is an unusual thing to many people. Then there's the involvement of a neutral. You've heard both of us say how critical it is to have the right neutral. This is to me, and I think everyone I've talked to in our working group, this is not for everyone. This is a very special kind of range of scenarios. And it really requires a degree of sophistication and experience that is above and beyond the norm. This isn't something for a beginning mediator or arbitrator. It also typically requires some kind of integration, an agreement in writing. And, you know, this is going to happen in many cases after the dispute has arisen, after a contract has been negotiated. So you may be creating an ad hoc agreement that includes all the mutual understandings. Now, let me bore down just a little bit on the neutral's competency, etc. Again, mediation and arbitration require very different skill sets. And there's also this notion that you want a high degree of confidence and trust for the parties to be able to engage in a process like this, particularly if there's a possibility that you're going to be moving back and forth between a process in which you have everyone in the same room and have ex parte processes. Oh, there's also issues relating to availability. We know today that as arbitrators, you know, we have an ethical obligation to think about our competence, our capability, but also our availability. And again, depending on the way a procedure like this is set up, if you've signed on for a mediation and all of a sudden the parties say, well, we want to arbitrate, then that requires an independent decision about the ability to arbitrate. Maybe it's not an issue in most cases, but nevertheless, that would be a question. And then, of course, there's the issue of independence and impartiality. And we're going to come back in just a minute to focus in on the whole question of what is are we going to caucus? And if so, how are we going to handle the information that may be flowing? Now, what's interesting is, the conversation over the years has typically been, well, you don't want to do mead-arb, single neutral mead-arb, because you have this flow of confidential information from the parties to the mediator, which might have an impact on the neutral's eventual decision. What's interesting is there are instances where the issue is a communication from the neutral to the parties. And we give one or two examples, as I said, of these kinds of scenarios. So to me, when you're talking about process, and when I say me, I mean the working group, there are significant issues surrounding what happens in mead-arb, where you have ex parte caucuses and you have communications going one way or the other. And so you have and this is kind of dense, but I'll briefly just touch on some of these options. We talk in our report about different process options, and certainly some, I think, to the working group are more favorable than others. But what we did was to collect all of the different choices that parties have talked about in creating a situation to deal with a situation where a mediator may at some point be the arbitrator. One possibility is, of course, and this is the most common, I think, an agreement that if mead-arb proceeds to arbitration, the neutral arbitration award must be dependent solely on evidence and arguments presented during arbitration proceedings and not on any other communications or information conveyed during mediation. Now, not every neutral thinks that they can do that. And so you do have some differences of opinion about whether this is possible. But with arbitrators as well as with judges, this is a question. Can they set that aside in moving forward? Now, I do want to say at this point, there's an argument that some repeat mead-arb people, or I should say, or arb-mead people give, which is, usually when we're an arbitrator and we switch to the role of mediator, we settle the case. So we never go back to the arbitral role, except maybe to issue a consent award. So all of this concern about, who said what to whom is not significant. At least it doesn't rear its head. That's something to keep in mind. Another possibility is, and I believe this is mentioned in a protocol put out by one of the major provider organizations, an agreement that the parties consent to mead-arb with full awareness that the information received in ex parte caucus may be taken into account in formulating the arbitration award. I have to say, I've not used this language myself. I don't know if anyone has, but it has appeared in print in at least one document. Now, another possibility that you see in some statutes, such as the Singapore Arbitration Mediation Arbitration Protocol, is, and also in the law of Australia, is a requirement that at the conclusion of mediation and before arbitration, the neutral will be required to disclose as much of the confidential information he or she received during the mediation as she considers material to the arbitration proceedings. So this, to me, is is a very interesting kind of arrangement. personally very concerned about this approach, but it is something that we needed to put in there and make everybody aware of, because when you get to the enforcement stage, there may be places where there'll be a question about whether you can waive this requirement of disclosure, and it may be deemed to be unwaivable. So these are all things to be thinking about. Another one, of course, is to say that the parties can reconfer regarding whether they want the mediator to continue as arbitrator. Maybe there'll be a requirement of separate written consent to have the neutral arbitrate after mediation. Another one would be an agreement to permit neutrals to recuse themselves at the conclusion of arbitration. There's one other possibility, and that is, and it's one that some of us have used from time to time, and that is don't caucus. Occasionally, mediators can conduct an entire mediation without going into separate sessions. Certainly, many mediators say, well, that's very hard to do, and the level of success is likely to be much lower. Nevertheless, that is a possibility in some scenarios, which might avoid issues relating to confidential communications and ex parte discussions. So, as you see, we spent a lot of time focused on these central areas. I'm going to stop here in about 1 minute, but I do want to identify some other things that the group talked about in terms of what we want to put in, what we suggest be put in an agreement in writing. One thing that sometimes gets parties into trouble is to not clearly demarc different phases or stages of a scenario where a neutral is playing multiple roles. And there have been situations where, for lack of clarity, courts have said, we don't know what this mess is. Were they mediating? Were they arbitrating? What were they doing? We're not going to enforce this result. Another issue has to do with reasonable allocation of time and a clear description of the character of mediation and arbitration. For example, particularly if it's an ad hoc scenario where you're trying to create an arbitration after mediation, there should be the opportunity to talk about the scope of the evidentiary hearing, et cetera, if that's not already set up. And finally, there should be some kind of waiver language, and that goes back to questions relating to communications during the ex parte proceedings, and we suggested one possible phrasing of waiver language here. So those are all issues that we wanted to go over with you. We do want to open up the floor to questions, and I'll invite Professor Moroni to add anything that he would like before we do so. But we do welcome your comments and questions and your input during the coming weeks as we conduct this consultation. Modi, did you want to add anything at this point?
Yeah, I just want to say something that we found it's very, very important also to find out not only what is the cultural, what's the culture, the bearing of culture on this issue, but also the legal constraints. Because, and I think one of our contribution, our guideline is the appendixes that we have at the end of our guidelines that really show you a very rich plateau of different approaches, legal approaches to mixed mode. And I think it's something that we should take into account. First of all, is it legal at all to do a med-arb or arb-med-arb or arb-med? I'll give you just an example. In our country, we cannot do med-arb in advance. Only at the end of the mediation, we can agree on it, but we cannot agree on it in advance. Another example be in sport disputes, when we go to the CAS, the Court of Arbitration for Sport, if you are a mediator in the CAS, you cannot become an arbitrator because they have separate lists of mediators and arbitrators. So you cannot, unless you are, and there are very, very few people who appear on both lists, but otherwise you cannot do a med arb or arb med arb or arb med in this situation because there are different lists. So, and this is why we will encourage both Tom and myself of the people who are interested in this field to look into their legal system and see what are the legal constraints, what is the experience, what court have to say about mixed mode. Because otherwise we don't want to have an exercise in futility, and we want to do something that it will be really effective and very helpful. And this is something that you people who come from all over the world can make a really great contribution to our working group. Thank you.
Thank you. Okay, we'd like to open up the floor to discussion. I know this is a topic that elicits very different perspectives from the standpoint of professional practice and policy making. But what we've attempted to do is try to come to grips with and accommodate different perspectives. But we would love to hear any comments that you would like to add. I see Pierre has raised the question, has anyone looked at whether hat switching raises the possibility of the award being challenged? You know, we do not have, I'm not aware, and I invite any other working group members who are online or anyone else we have nothing beyond anecdotal evidence. And we have tried to provide examples of different sorts of scenarios where challenges have been raised, and we have looked at some of the different kinds of statutory responses that may raise concerns.
I just want to say that our jurisprudence say we had several cases in court, and by the way, this is why it would be interesting for you to look into the different appendixes. Our Supreme Court said that mixed mode is a very legitimate way to resolve a dispute. Two cases of arb med arb. In both of them, the losing party raised an issue, tried to change the award or quash the award, and in both cases they failed. So I think it's very, very important really to learn what is the jurisprudence from around the world about it, because this is something of concern for sure. And this is why the question is really an excellent question.
Okay.
Another
a
question raised also by Pierre is, what happens when you have a 3-member panel and only one is asked to act as a mediator?
Can you repeat the question?
What happens when you have a 3-member panel and only one is asked to act as a mediator?
In an arb med situation or in arb med arb situation? I just want to understand.
Well,
maybe be more specific, because we so far, and I think most of our guidelines really, we focused on a single arbitrator, a single mediator switching heads. But the panel of 3 is really interesting because then one can be a mediator, and then there are maybe less problem with ex parte communication, and this raises a very interesting new set of questions for us. But our guidelines really, we didn't think about a 3-member panel at all. But it would be interesting, for example, maybe the 2 side arbitrators in an arb med arb or arb mid can mediate, and then the neutral can be the arbitrator, and this is really interesting.
We have several other questions, and I wonder if I might invite comments by those who have raised them. Tanya Goddard made a comment about due process. Tanya, would you like to express the concern that you raised?
Hi, yes, good day, everyone. The issue concerns with perception of the parties. Even if in instances where there may be guidelines to direct, you have a case in some jurisdictions where they're not comfortable with information which may have been relayed during the mediation, and therefore, how do you assess parties' due process concerns, which is, for those of us following the arbitration, would be one of the ways they would, if a party didn't want to engage in more, raise a challenge. How do you adjust? How would the person address that? Would be my concern.
Well, one of the ways in which we are attempting to address that is waiver language. The question and other process choices, which would either avoid ex parte contact entirely or give parties an opportunity to opt out or to do a renewed discussion of the ongoing activity of the neutral. Say, do we want this person to continue? And if they both didn't agree, then one would stop. Clearly, I think there are jurisdictions in which requirements of disclosure are so significant, and this includes Singapore, Hong Kong, and Australia, that it at least raises questions about the efficacy of a waiver relating to ex parte communications prior to coming back and being an arbitrator. I think, again, I want to emphasize, this is a very interesting problem because a number of people, including some in our working group, have said, well, we think the issue that is being raised is overstated. But we do also know that there are circumstances in which, the parties come back to arbitration and someone is dissatisfied. And we give those examples as well. I don't know if that's a complete answer to your question, but it's an excellent one. Let me ask, we've been getting a number of different comments. Gabor, did you want to add something, raise an issue or make an observation?
Well, a lot of things that I find troubling, particularly with the literature that has shown how judges' decision can be extremely biased depending on the time of the day or even the temperature outside. So if you combine this information that came out in Daniel Kahneman's previous book and the most recent one, Noise. So if you combine the information that we know and consider how this might impact someone who will be changing hat or hats, it's very troubling. And I don't know what to make of it. That's why I was asking, we're looking at the legal implications, but what are the philosophical implications, knowing what we know?
Well,
knowing what the neuroscience has told us about this.
And so I'm sorry to interrupt, Gabor, but I certainly understand your comment about the philosophical considerations, and we try to address those right off the bat. Again, I want to emphasize that our practice guidelines are not saying please do single neutral meet arb. We're not advocating a particular approach. We are saying if you are going to consider doing this, be aware that there are pitfalls, there are potential problems, and we recognize that many neutrals and many attorneys will never go down this road. what we are attempting to do is to say, here are the issues you need to deal with. Here is our recommendation for a set of things you need to be aware of and address if you're going to do this. And you do have process choices. Again, I actually had two scenarios where, as an arbitrator, I was asked to help the parties negotiate. We mediated resolutions in joint session, and then I issued 2 consent awards. That was the end of it. I didn't deal with ex parte issues. Some people would say, well, I can't mediate that way, or not in most cases. So, you do have, what we're trying to do is identify the decision points and say, we recognize there are very different philosophical approaches. And what we're trying to do is to say, let's cabin the discussion, try to lift up what we can in terms of the considerations that people need to be aware of. Because what we see is it does happen more often than you might think. And many neutrals encounter this. So what we're trying to do is to say, not, oh, go do this, but to say, if you are going to do this, be aware of this, particularly in an international scenario. So, but I think your comment is an excellent one, and really, we really appreciate that. Let me, how are we doing on time? We have a few minutes left.
I wanted to say we do only have a few minutes left, but we do have a break following this session. So I think some of even the co-chairs may have to go, but if you wanted to take a few more minutes, and people should know that if they want to go off at any time and go get a cup of coffee or whatever, it is supposed to be a break. But if you guys wanted a few more minutes, we have 15-minute break now.
All right. We're getting some wonderful questions here.
Very important.
Is there, I'm curious to know, would anyone who would like to offer a comment to the group who has raised a question, or anyone else, you'll raise your hand or raise your electronic hand. Eric, would you like, I noticed that you made a comment.
Yes. My comment is, it's not just arbitration, mediation, whatever. It's, if I start mediating and then I realize the best way to do it is to get rifle shot saying, well, if I decide this issue, would that affect you, or that issue, and you start rifle shotting pre-hearing issues going forward, it's very helpful because they're seeing my thinking and evaluation on some of these issues, but it also may delay, and it also may have some of the parties think I'm already biased about it.
Yeah. And that's, again, a wonderful cautionary comment. What we are attempting to do is to say, what are the things you need to be thinking about if you want to go down this road? Again, we've seen people do this. Most times the neutrals say, well, it worked out okay. But we know that there's nervousness about a number of these questions. And so what we're really trying to do is to promote party autonomy by saying, you want to do this, okay, well, here's a pathway, but be warned. Who else would like to raise an issue with the group before we move on? Barbara Reeves, did you have a comment? Oh, no? Okay, sorry. Let me...
just a comment, Tom. Just a comment. What happens, excuse me, what happens if an arbitrator is solicited to act as a mediator and he refuses because he's uncomfortable?
And that happens. There is an example. I mean, that happens all the time. People may say, I'm sorry, I was hired as your arbitrator and I can't take that step. There are lots of highly experienced mediators who you can reach out to, and that's what I would encourage you to do, and that's the normal approach. There's another. I'll give an example of another situation where problems sometimes arise. There is a habit of some neutrals in the United States, when they've mediated dispute resolution, to put themselves in the agreement as an arbitrator of disputes. And in at least one case here in California, that has raised some issues, because the neutral was then called upon to arbitrate and was uncomfortable. And I don't know details, but the neutral was uncomfortable with actually serving the role of arbitrator, even though, you know, that this person had agreed to put their name in as the arbitrator to manage to resolve conflicts under the prior mediated agreement. So, you know, there are these kinds of issues that can arise, and we continue to, several people have cited cases. Let me just say that because time is very short right now, and we do have some scheduling issues, personal and otherwise, to the extent that you don't get airtime here today, we hope you will share your comments with us by email or otherwise. Contact any member of the working group or the task force. And many of you know how to reach me or Professor Maroney, but certainly you can reach out to our other colleagues if you have questions or comments that you want to share. Do we want to try to do the poll questions for this group, Kathleen, or what's your pleasure?
I think that it would be good if people do them. They could also do them, you know, if you guys had more things to talk about, but they're up now. Why don't we do them?
Okay, what we'd like from you is to know if you have had a chance to look at the guidelines, or at least a description of the guidelines. Do you feel that the guidelines will be a useful contribution to commercial dispute resolution? That we also have a question. Do we have all of the questions up? Yes, we do. If you agree that the guidelines will be useful, how do you believe they may be of use? Will it promote better decision-making by legal counselors, educating clients, improving practices in international dispute resolution, promoting better decision-making by law and policymakers? What might it do? If you don't agree that they will be useful, or they could be more useful, how might they be improved? Providing shorter, simpler guidance, providing specific templates. The guidelines cannot be made useful, providing specific examples, and also you have other suggestions. The appendix of the guidelines offers information on relevant law and practice and perceptions in different countries. And we'd like to know if you would be willing to provide info on your own legal system. I hope we can go back and trace who said what so that we can check with you, because we are trying to develop a compendium of information on this. So love to have your comments with respect to either, the utility of these guidelines, ways of improving the guidelines, and contributions to the guidelines. So, Kathleen, I think we're going to need to wrap up here pretty quickly.
What I just wanted to say quickly, Tom, sorry, is that I do think, for those of you who don't feel like you're sufficiently well-versed in the guidelines to answer these questions now, we will be sending a poll around in more of a SurveyMonkey format, but it will repeat these questions and perhaps add some as well. So if you do have a time after this and would have time then to answer that survey, it would be terrific. And the other thing is, I don't think that we will be able to figure out who said yes or no. So if you have any interest at all in providing comments on your own jurisdiction to Tom, please send an email to Ivana or to Tom or myself, someone on the working group, and we'll make sure that gets back to Tom.
Please let us know.
The one thing I want to say on the enforceability issue, just quickly, I mean, one thing that we saw in looking at the enforceability issues generally is that, the question of whether consent should be given after. So if there's been an arbitrator that becomes a mediator and wants to come back to being an arbitrator, that specific context is the question is, do you ask for consent again? And if you ask for consent again after the mediation has taken place and you know what the arbitrator knew, et cetera, that can be helpful in terms of enforcement. Not necessarily necessary, and it depends on the jurisdiction and all that, but asking for consent again after the mediation is helpful and would have saved an award or two. So
I just want to say for a conclusion that first of all, it was really a lot of fun to work on this issue, and I think especially working with Tom, and it's a very challenging issue. And I think as a mediator, I would suggest that every time when people come to you and ask for a mixed mode, you should ask them why they want the mixed mode. This is why is the question that mediators keep asking. And I think we have to ask this not only about the substance, but also about the process. And once and why you need a mixed mode. And I think if they know why they need mixed mode, and then they can consult the guidelines, and they are sure that this is what they want. I think it's a very, very powerful and very efficient tool. And secondly, I think that the neutrals should be more aware of the mixed mode and our guidelines, and be able, and I think it will enrich their practice if they can, if they want, if they are willing to practice mixed mode. And I think this is the future. The future for me is the mixed mode, and this is the reason why if we want to be really dispute resolvers, I think we should offer it as part of our toolkit.
We want to thank all of you for your participation. Kathleen, thank you for the airtime, and Ivana, thank you for your wonderful management of this whole process. We had a lot of people say they would like to give contributions about their own experience, about their country. Please reach out to us. Let us know. Modi and I and the whole group are very interested in expanding the discussion. Thanks again, and God bless everyone.
Super. Thanks, Tom. Thanks, Monty. So I think we're going to take a break, believe it or not, a short one. I find it easier not to actually exit, just to shut off my screen, but we only have 7 minutes. So we'd really like to come back at the half hour so that we are friends from Working Group 2, who will start at the half hour. And that will be Laura and Jeremy, who will start at the half hour. So thank you so much, everybody. See you again in 6 minutes now.
Because it comes out of the work of all of the work of the task force, because the thinking is that if we are going to mix and match processes, do we need help in designing that process from the outset? So Jeremy, do we have the slide with the background one?
Yep. So here are some of the background information.
So the global PAM, which Jeremy was very instrumental in, really showed us that people are looking for solutions quicker and less costly solutions to their problems, and that the client, it was very interesting in our last session how concerned neutrals are about different switching hats or different processes. And that's totally legitimate, but the clients don't understand, some of the clients don't fully understand the differences, or they don't care about the differences. They want a result. So Jeremy, why don't you speak a little bit to the Global PAM findings?
Well, I think they're actually pretty self-explanatory here, but it's a combination of really 2 and 3 that's interesting. So yes, they want efficiency, but they do want collaboration. And it seems to be that sophisticated users are almost sick and tired of kind of how cases escalate, lawyers end up fighting, and things get lost in the swamps of motion practice or a kind of bickering between lawyers. Tribunals don't like that either. So I think there's a great push towards this as well. And I think we said it earlier today, in-house counsel are actually seen to be not as active as they should be in this. They are seen to be really able to change and drive a new kind of paradigm of thinking. And yet, you know, many of the associations of corporate counsel are not very interested in this theme. They haven't taken it up actively. There are some exceptions, RKTMT in Germany, for example. Kathleen was just showing me their website the other day. But you know, those are the exceptions. And I think that's something we should just be mindful of. But there is this new trend. You could say this data goes back to 2018. You know, what is the relevance today? Just again, the 2018 data, if you look at it a bit more closely, you see that when people were asked for the future, what is more important? First of all, nobody wanted to rely more on adjudicative systems. It was a very unpopular choice. And what people really wanted was this combination of preventative pre-dispute or combining processes, which is mixed mode, or moving purely to non-adjudicative. So these were the preferences back when we did this with, you know, 4,000 inputs on this. Really interesting. I don't want to go into this is a very busy slide. What you'll see here is a question from the Global Pound Conference. We asked the question, you know, what role do parties involved in commercial disputes want providers to take at the outset of the process? And the answers seem to be unanimous across all stakeholder groups that you see on the bottom. We actually don't know what we want yet. We want guidance from the providers in the beginning on process and what can be done. So it seemed to be that people are saying, yes, I might have hired you for arbitration. I might have hired you for mediation, but really, I want to know what my procedural options are. That seemed to be what that vote suggested quite uniformly across the board. And the idea is that the providers would decide process and the parties on the outcome was the second most popular option. So that's just something to be aware of. This idea of party autonomy certainly on outcome is very important. And they're willing to kind of abdicate first on process before they're willing to give up on outcome if you look at the results, which is quite a few people from around the world. This was all confirmed very recently. You heard it this morning in the call with UNCITRAL's first academy. They had a 57% vote on mixed modes being very important for the future. But last year, there was also a survey by CIDRA, same percentages. This is a topic that without any influence by anybody involved in this panel, and we saw ICC moving this way, and I see that Alan Waxman from CPR is on the call, and I know they've been thinking about it, and clearly AAA ICDR have been thinking about this as well. WIPO and its rule has always provided for this flexibility. It's there, and I don't think it's going to go away. It's part maybe of the post-COVID changes. As in the same way as people are more open to new technologies, I think they'll be more open to process design.
So I just want to reinforce that our idea of this group is that if we are going to move toward more creative intermixing of different processes, people need some help in designing that. And so that was what we were tasked with doing, and to think about the role of the neutral who will facilitate the thinking about the process.
So moving on to the next slide, we just see, you know, we've been doing today's session out of chronological order. When you see the 7 working groups, you will see that there is a chronological order to them. Pre-dispute kind of closes us very early on doing, you know, thinking about how do we do tailored process design. Then the idea of mediators, you know, that was with the 4 quadrants. So how do we balance between evaluative, non-evaluative input, the arbitrator setting the stage? You know, there's a certain logic when you follow it chronologically here. We are now jumping back in time to working group 2, having already done the switching of hats. Important that I think is worthwhile mentioning is all the 7 groups, we're trying to take in mind 5 key drivers that we in our working group built into the process as a systemic approach. But the key drivers that we're looking at are cost, time, enforceability, self-determination, and relationships, or what we can consider harmonious way of working together where maybe the individual relationships don't matter, but it's more the harmony that in a collectivist culture, for example, might be more important. And we're trying to think of practical results that will be useful for neutrals, but also for end users, because that's who the audience we're trying to work with. So maybe moving on, the concept for us, we're looking at this idea of early on, how do you design process? And there are three different ways that we saw earlier in the comments. People tend to think of this either sequentially, and this is how most escalation clauses are written. They'll normally start with mediation and jump to arbitration. The idea of conciliation being a separate practice, as we've heard, being maybe a polemic one, subject to debate. Or people think of it sometimes as in parallel. We'll have an arbitrator, we'll have an arbitration going, in parallel we'll have a mediation, but we'll keep them kind of hermetically sealed off from one another. Maybe we'll allow some shadowing of what's going on, but they're really very distinct processes. There's no communication between the neutrals. The more interesting one, and this is what Working Group 7 will be challenged with and has been working on, is can we integrate? Can we actually have mediators and arbitrators working together as a team and working out these issues belong to arbitration, these issues belong to mediation, let's agree on how we allocate them, let's agree on how we structure it, let's discuss these kinds of things. And for us to have these discussions, there's a concern that you can't really have the neutral say, well, I will do everything for you. I will swap hats. I'll be both the mediator and arbitrator, or I will tell you what I think the right process is, without a loss of face or the parties feeling this is the wrong way to do it. And we got onto the idea in Working Group 2 of let's maybe bring in early on a new person. A person, maybe this is what ADR providers should be providing as a service. Maybe some of them actually do this. But do we want to bring in a person, especially if it's an ad hoc case, where the person's first job is not to try and act as a mediator or as an arbitrator, but to work as a process facilitator and think about these issues and help the parties think about them and how do you do it? And it's interesting with the early votes that we saw this morning that people were saying, well, when do you think about these things? People said it's got to be in the contract. So,
Well, yeah,
and that's the voting that we saw this morning in the first poll, Laura. But go ahead.
I just wanted to add, because we've talked about it as sequential, we talked about it as parallel, and we talked about it as integrated. But what we're talking about now is the assessment of the dispute as an individual dispute, not as a sort of global way of approaching something, but the assessment of this particular dispute and how that dispute could be most effectively resolved using the process mediator to figure that out at the very beginning.
So that's what we're looking at, this concept of bringing a person in. And for us, there are this concept that 5 key drivers will help us kind of to guide the thinking of how do we want to do process design. And again, early on, this is before you file your complaint. This is before you have a decision. This is really, you've first realized there's a dispute. How do we work out? And if you think that we are missing any of the key drivers, please let us know. That's a first comment for the chats that we ask you to put in. But for us, the idea is not only do we think about it, but what we are suggesting with our recommendations is a structured and systematic approach to involving all of these key drivers early on in a dispute.
And that's really, really critical, but it is also possible to use the process designer throughout the dispute. So it doesn't matter if you forgot to do it at step 1, you could go back later and do it at step 3 and use someone to help you. You've realized there's an element of the case, a motion or a legal point that if resolved would really help the parties move forward. Maybe then is the time to do a new thinking through the process design.
And the whole idea here is that it's a continuing resource that, yes, you rely on heavily at the beginning maybe, but is always available, especially if things do go wrong, because things sometimes can. But these are the things to think about. How can we apply this systematically in the assessment? So we came up with, and I think we can go through this quite quickly because this is the old version of what Working Group 3 improved on. So the idea was that if you looked at the old grid of Riskin, you had this idea of separate process from substance, and then try and work out where were you, A, B, C, D, in these different quadrants, with the idea that, you know, if you had the parties agreeing where they wanted to be, this could in itself be a triage mechanism that can help them. So it was a first diagnostic tool. We're just trying to show you some of the diagnostic tools we think can be used early on. And to be really clear, this does not mean the whole dispute has to be run this way, because you can start in one grid and move around, or you can combine, or you can break it up by topic and say, well, the question of quantum, we want it resolved in quadrant C, but the question of causation, we want it to be in quadrant D, and the question of future business relationships, we want that to be in quadrant A. And yes, we might want the same neutral. We'll break down the agenda and we'll say, when you're doing this part, do it this way. But you know, this has been improved, as I say, by Working Group 3, especially in my view, with the concept of the zone of permitted evaluation, because then it really makes it clear that you need to check that you have the parties' consent to provide any evaluative feedback first. So that is that. The other diagnostic tool we just wanted to share with you quickly is a Glasgow scale. In Europe, this is a very common training in mediation. You have to look at conflict escalation. You've got to look at the propensity of the conflict to escalate further. And there is a belief that sometimes the neutral can contribute to conflict escalation. Not because they try and do it, but simply their presence, if they're going to be evaluative, means that the parties can view the neutral as competitive grounds. So you want to try and convince the neutral that when they do make their mediator's proposal, they will be, they're facilitative now, but we know that at the end of the day, when they make their mediator's proposal, we want them already to be making the proposal in our zone of, you know, where we want it to end up. So the idea is that it creates a danger that can lead to conflict escalation because you try and build a good coalition with a neutral because he might be evaluative down the road, which is why the Austrians, as I was saying in a previous session, believe that a mediator should never be evaluative because there is a risk of contributing to downscale escalation of the conflict. So this is a concept in itself that's important. You know, when do you caucus, not caucus? The belief is that in certain conflicts that the emotions are very strong, the people are in this 7, 8, 9 range, you know, where you have just, you know, managing the other as a threat, emotions are strong, caucuses work well. And arbitration litigation are seen as highly effective more at the tail end, but you'll see what Glasgow calls the lose-lose end of the spectrum. And the idea really is at times, how do you get them back into the win-win? And that's where mediation and conciliation can be interesting. There's some interesting neuroscience behind this as well. But what do you do in group dynamic? What do you do to social plasticity of the group of people? Do you drive them and prime them to be thinking of themselves as opponents with different positions? So when you ask for a position paper, are you priming people to think of themselves as adversaries? Or if you ask people for interest papers or mutual interest papers, you know, what are you having there as a different vocabulary to prime things? The idea being that, you know, if people want to be in that zone, you need to help them de-escalate first. And how can you do the process design to help people de-escalate? And sometimes it's as silly as we'll have a meal, and around the meal we'll discuss these options. But this is just an example of one of the diagnostic tools that can be used. Now, with our group, we couldn't come up with any recommended diagnostics. It's far too early. Nobody is doing this yet, but we found an existence of several diagnostic tools. The German consortium from industry that I mentioned earlier, RTKMK, I believe it's called, have a website which helps you to do conflict diagnosis. CPR did some early case evaluations. If you remember, they would really help you also do kind of a triage. But there's not much, and IMI has a website that helps you think about the different styles of mediators you might want. But these are all factors that have not been brought together. And we think that if the future is going to be mixed mode, then there's a need for good tools and best practices for diagnostics. And while we've published our paper about this, we are not ready yet to provide best practices. And we were interested by the reactions.
I just want to add to that. because I think it's very important. We're at the beginning of the process, not at the stage where we can evaluate what anyone is doing and whether they are good or best practices, because there are so few people actually engaged in this. So I think it's consistent with what we heard before. The industry, all the neutrals, need some help in beginning to understand how they can diagnose problems and in the forms that they can use and processes they can use to help the parties understand what the processes and the choices are.
These are just examples. So moving ahead, so what do we try and do as a working group? We inspired ourselves very much from Paul Lurie and the whole group of people involved in guided choice. It's a bit different from guided choice in the sense that we are not suggesting that the process kind of facilitator be the diagnostician necessarily. They're not the one who's going to come and say, well, here's what you need to do. They don't know the issues yet. They don't know what's going on early on, but they facilitate the discussion around this. And so there's a commitment just to focus on process issues first. Then the idea is you use the 5 key drivers consistently and try and use diagnostic tools that still need to be evaluated and created. And it's only then that you do the bespoke process design. That will then lead to a need to disclose how does the neutral plan on doing this. So this idea of disclosure, will I be evaluative, will I be non-evaluative, will I give a proposal or not, that all needs to be kind of then understood and discussed with everybody's consent at that stage. There might be a need for information exchange, documents, whatever. All this will have been discussed based on these issues. You can also try and pre-anticipate impasses, what information might be helped to overcome those hurdles. And then you can have this ongoing role of the facilitator, as Laura said. So it's not just the beginning when you're setting it up, but they're available as a resource throughout, which is, again, maybe a new way of looking at what ADR centers could or should be providing in the future. And then you try and work out the different topics that might require expertise or evaluative input. It's highly technical. There's a causational issue. We need engineers, we need chemists, whatever it is, to understand that. But still, at the end of the day, once we got the feedback saying, yes, it's more likely than not caused by X, does that really change what our future needs and interests are for finding a solution? This is a bit some of the difference. It's similar to guided choice for those who are similar, but it's different because we're really trying to look at it holistically with this idea of also the code of disclosure incorporated into it of you need to adapt the process to what you've agreed to up front. It's not just for a person to run it. Now, feedback that we had in the working group when we ran this with a group from CPR, first of all, there's some fear that the moment you use the word bespoke or tailored, you're talking about something necessarily more expensive or more lengthy. So even though the designer could come in and say, I'm here to make sure you have an outcome within 3 days and at a cost of no more $30,000 collectively or $10,000, whatever it is, it could be that you know the parameters are to set the date and the deadline and to set the cost. And we can give an example of how that could be done so that you can work on a fixed budget and have an equal budget by everybody. So there was that first kind of fear. There was also very interesting feedback that we had that many mediators, many of the users who were in-house counsel thought this is what a normal mediator does. This is actually normal. A good mediator who knows what they are doing should be doing this work up front. But as we saw with the polling earlier today, many mediators don't do this. And if we looked at the statistics earlier with the voting at the beginning of the session, we saw that actually 2/3 do not do this very often. It's very rare that early on you do this.
So can I just add, because I think the mediators do some form of analysis at the beginning. What's unique here is I don't think they often think of an evaluative component to be built into the process of mediation, or the difference between conciliation, for example, or even the nice grid that we got from group 3. They don't think about those as real differences necessarily.
So these are some of the differences, but we did try and come up with a model clause. So the idea here is a clause that could be put into contracts that, and there's a lot to read here, so we don't expect you to read through it. Basically what this says is, we agree now in the contract that if ever there's a dispute, we will hire a neutral third party. We're giving them the title, in this case, of a guiding mediator, because the concept, the word mediator in many cultures automatically assumes confidentiality. It's immune from discovery. And also the idea that it's kind of a process structured with an accredited neutral who knows what they're doing. But we got some mixed feedback on that. It's one of the questions for you. Should this person be called something other than a guiding mediator? But because we were influenced by the guiding choice movement, we used the concept of a guiding mediator. But the idea is this person will be appointed early on, and they will help the parties to design an optimal process for early and mutually acceptable resolution. And so the optimal process should be cost efficient, take into consideration relationships, commercial interests, as well as other things such as enforceability, remedies, deadlines, etc. And they'll work in strict confidentiality. They'll provide non-binding recommendations on process because that might be helpful, so that their expertise can be brought in, but it does need to be relied on. Again, it's more conciliation on process issues than arbitration on conciliation issue on process issues. And they'll be granted all mediation privilege and professional secrecy status that is normally attached to mediator, because many legal jurisdictions might understand what that means. And once appointed, there was this idea, and there was a whole debate, should the guiding mediator be able to act as a substantive mediator arbitrator? And we said yes, but with the prior written consent of the parties. So you've got to decide that issue now, because otherwise there's a presumption that the neutral will not be acting as your mediator or as your arbitrator unless you've covered that point right now. And so the idea is you don't agree on process yet. You wait till you agree simply to appoint a neutral, and within 30 days, you're going to try and do process design first. Now, if it fails, that's where the backup clauses in the little blue rectangle on the bottom say, we put in for arbitration as a fallback if this doesn't work. Or you can go to court litigation, it can be institutional or not, but the idea is that you kind of have built into this escalation in case process design fails. So this is the clause that we came up with. We'd love to get your feedback on the clause. It's difficult to read and give feedback today in this call, but it would be really helpful if you would look at it in the future, provide feedback. The working group that we worked with from CPR and other feedback from in-house counsel was they were very afraid of this clause. They didn't like it. They thought this was somehow adding costs or expenses early on. This just seemed to be very, very kind of complex, maybe for very big cases, but there was a certain fear of putting this in the contract. However, as we also saw in our earlier poll from today, very few people are likely to agree to this post-dispute arising. So it's very difficult to know how to put it into a contract because although it's available post-dispute, we know that it seldom happens post-dispute early on. Just to give you some examples of what we meant by how you can do things within fixed costs and fixed budgets. The first one is not med-arb, the usual escalation, moving from mediation to arbitration, but arb-med. You do an arbitration before a mediation. Now that's a bit unusual. It can be very helpful when you got quantum disputes. It's been used, we know, published in case of intangible assets, a trademark portfolio, for example. What's the valuation of that portfolio? And there's a dispute of the valuation of the intangible assets. Very difficult to rely just on expert opinions. There are all sorts of other considerations. So ARB-MED works very well in these cases. So to explain the process, you first have an evaluative process. In that case, it was arbitration of 3 hours. Then what happened is the arbitrator, normally a sole person, will just write a number in an envelope and leave. The envelope sits on the table. The parties come back from their lunch where they've been able to build a social rapport, and then the mediator kicks in. And should they know what's in the envelope? Should they not know what's in the envelope? There are lots of thoughts about this, but the idea is normally they don't know what's in the envelope. And if they don't reach immediate outcome by 6 o'clock in the evening, that's the fixed time. They open it, and whatever's in the arbitral board will be binding. And that doesn't suffer from any of the problems that you have with ARB-Med and what knowledge was shared in caucus, not shared in caucus. It puts psychological pressure on the parties to settle. So the arbitrator gives a decision first in a sealed envelope, and then the mediator, normally without knowing what's in the envelope, helps them to find it out. And whenever it's been done, I've asked the people, did you ever open the envelope? And they said no. You know, that will leave a person unhappy. So normally the envelope is torn up if it has not been opened. And interestingly, nobody told me of a case where they did open the envelope. It seemed to be that having the envelope present was always helping to get resolution. Now, should it be the same neutral to do this, swapping hats? We'll just refer you to the whole discussion we had with Working Group 5. There are benefits and sometimes disadvantages to this. Laura, do you want to say anything else about ARB-Med?
I don't. I think, of course, from our perspective, this is a design problem, not sort of the questions that were raised in the switching hats discussion, but that's part of what the designer would think about is what needs to be disclosed and what kinds of rules need to be established around the process.
The other example that you might be more familiar with is Medloa, mediation followed by last offer arbitration. Here, the presumption is almost the same neutral will act as a mediator and as an arbitrator. The difference is that when they shift to the role of arbitrator, they can only choose between two final offers. Each of the parties makes one final binding offer of what they consider to be the most fair final offer based on the mediation, all the information exchanged, everything that was discussed, and they provide their final offer. And then the neutral can only choose between the offers. And there is arbitration because you still have the dispute, it has not been resolved. But then wearing their arbitrator hat, and whether it's principles of fairness or whatever, they will decide, okay, I'm going to accept this as the binding offer because that's the rules of the game. Whatever I decide is the best and fairest. Now, there are some variants to this. One of them is that the arbitrator knows of the offers before he decides. He reads them and says, well, I agree with this one. Or first, that you can sometimes ask the arbitrator to think, okay, what do I think is the most fair? And then once that's been kind of annotated, written down a certain way, then they can compare the offers and see which one benchmarks closest. I'm not sure this has an advantage to it or not. There are lots of different variants on this, but both of these examples we've given you, ARB-Med and Medloa, are examples of how you can say up front, we can do everything in a 1 or 2 day period. It's rough justice, but it also puts pressure on the mediation to try and compensate for where the arbitration might be less than perfect. But if that's what the parties want and they're sophisticated and they sign the waivers, why not do this?
Jeremy, I think we need to move to the questions.
Yeah. So moving on to the questions, and then we'd like to have your feedback on all of this. And yes, we did do a bit too much on presentation today. Well, first of all, the results were very clearly that around 30% of the audience had not really read the papers. So I think we needed to do what we did, or hopefully tell us for the next group. We'll be repeating this in a few days' time. What I'm going to do is I'm going to move to a series of questions that we had for today. So I'm going to launch the questions. And so, sorry, that's not Working Group 5. Sorry, that's not the right group. I'm going to stop that one. I thought I was doing Working Group 2, beg your pardon. So
Jeremy, I can do it. Here.
Okay, I think it's good now.
Yeah.
So Working Group 2. So there are a series of questions for you. The first one is, a process design session should be organized early on in most disputes before proceeding with either mediation, arbitration, or combined process. Please, can you vote your kind of thinking on that? And there are 35 of you can vote, so please do all of you vote, because it's really important feedback for us to know what your thoughts are on this.
Please vote, guys.
Regardless of whether you read the paper.
Regardless of whether you read the paper, indeed.
Description.
Yes. Yes, we really want your input.
So only 6 of you so far, so I'm going to wait before we move on to the next question. Good, so they're starting to come in, but we're not at 50% yet. We're only at 37% of you voted at this stage. Come on.
Well, in truth, Jeremy, some may have stepped away from their computers.
We know that. We know that. But it is moving up. So now we're at 54%. And I'll go through the questions, but please do vote on as many as you can. The next question, number 2, is this concept of the 5 key drivers should be systematically used in most disputes to discuss process design issues. What do you think of these 5 key drivers is what question 2 is about. Question 3 is if you are going to appoint such a person, because we got into this whole question of nomenclature, would you prefer the heading, appointing the person as a consultant, as a process consultant, process facilitator, process mediator, guiding mediator, mediator, or you have no opinion on the matter, or you have another name, in which case, please in the chats, why don't you suggest what do you think the other name should be? That's question 4. And I think that's all the questions that maybe we were allowed. No, we have, no, that's all we're allowed, 3 questions. So there will be another, in the final poll, we'll be asking a bit more. But we now have 74% of you who voted. That's really good. And I'll leave it count to 5. In the meantime, we leave the votes open. Does anybody have any thoughts, comments, reactions for us in the 10-15 minutes we have left before we have to end this session?
We have 6 minutes, Jeremy.
6 minutes. So any feedback in the 6 minutes that we have left? And we encourage you to unmute yourselves.
Jeremy, you might want to take your screen down so that people can.
Sure, I'm sorry, I forgot to do that. Yes, thank you.
Paul.
Video is not open. Video is disabled. Video is not open.
But Paul, we can hear you.
Okay, I would add to the 5 factors to be considered. I'd add bias and heuristics. That one of the things that a mediator must do in pre-mediation diagnosis is figure out who the decision makers are and what kind of personality and issues they have about how they make decisions. So before you, as mediator, suggest the process, you really have to understand, basically you have to understand Daniel Kahneman.
So Paul, that's a great idea.
And a lot of mediators don't. A lot of mediators think it's only about money, it's only about economics. And they don't understand that oftentimes impasse is based upon psychological problems.
So Paul, let me turn that into a question for you. Would you, as a mediator or as an arbitrator, feel comfortable telling the parties in the beginning, well, we're going to run a psychometric profile test. We're going to do a personality profile test of any neutral coming in, and we want to do that. Or you see, so the question is, how do you account for this without doing some kind of questioning or getting some feedback? Now, there is artificial intelligence out on the internet that will allow you to do a personality profile without a person even knowing it. If you look at Google Plus or LinkedIn, you can run a personality profile on some people.
I think you
very worrying.
Okay, let me answer your question. Let me answer your question with specifics. We, at the American College of Construction Lawyers, we've really been working on all these things and producing service products. And to answer your question, you should read the book by Gary Furlong called Conflict Resolution Toolbox. And what Gary Furlong has done, it's in a 2nd edition of his book, is he's taken Daniel Kahneman concepts and put them into practical terms so that you're not giving psychological tests, you're knowing how to ask questions. That is the key thing. And a lot of mediators don't know how to ask questions in order to find out what the real impasse problem is and the people I'm involved with really are focusing on training mediators, not writing clauses, and they have charts, and we need to train mediators. It's like going to the doctor. You go to the doctor, and the doctor diagnoses you and doesn't sit there reading books in the middle of the diagnosis. The mediator knows what the choices are, and he or she is looking for symptoms to show what is the diagnosis for this impasse.
So thank you for that feedback. And it's good to know Kahneman is being brought in. There is a fear, though, that Kahneman is only looking at cognitive decision-making, not emotional intelligence issues. And it's also not taking into account social dynamics and social plasticity issues. So Kahneman has its limitations, but it's good to know that we're beginning to think about that. But these are, I think, considerations for the future. As AI comes in, I think we'll be faced with some choices on neutral selection that will be far more, because if you can get a psychometric profile about a person without them even knowing it, how many counsel might do it without anybody knowing? How much will the parties do it?
Could I just volunteer that I think that would be truly a moral morass for the
And a
media.
data protection violation of insurmountable,
Actually, Kathleen, we can have that conversation another time, but know that it's available on the internet already, and it's acceptable under GDPR practices because people are giving their consents in LinkedIn and in other places, and the information is there.
Consents aren't valid in those contexts. We're going to have to take this offline.
Okay,
buddy.
we'll take this offline. In the meantime, let's look at the results of the polls, because I think that's a good way for us to...
I'd like to bring up the philosophy question that I brought up again, in light of what you're discussing now. It's truly a moral issue, and if we do as mediators, if we get into this kind of approach, how unbiased can we remain? How can we maintain our neutrality or multi-partiality if we discover things about the persons we are dealing with that have an impact on us?
Jeremy, can I say, let's stick with our program?
I think so.
A whole new
Can of
morass
worms.
that we don't need to investigate at the moment. Let's stick with our
Got 1 minute.
We'll take it
demanding
offline. We'll take it offline.
agenda.
But thank you for voting, because what we see in the results are, first of all, there seems to be quite strong agreement. If we add strongly agree and agree, we're again at over 70%, thinking that it should be done early and consistently. So there's a gap between what is actually happening, people think should be happening. Then the other question that we had is, are the 5 key drivers useful? Polls told us how we could improve on it. We have, though, some people who disagree. It's 4%. Can we ask you to please, in the chats, let us know why you disagree? That's really important feedback for us. For those of you who are neutral, undecided, is it because you see some concerns? If so, you too, please let us know your concerns. Those who agree, that's nice to see, again, over 70%, but that's not even the issue so much. We're really interested to know what the concerns are, but thank you, because it looks like the 5 key drivers is getting support from majority. Then we have the results on for question 3, what to name the person. Process facilitator seems to be much more popular than process mediator, so we will definitely take note of that. That's we might have been too influenced by the concept of guiding mediation, and we should think about and revisit that. And again, thank you for having put in those who think a different name should be put in, like process manager and other things. Up, Laura, Kathleen, sorry, and thank you for your time, everybody.
Thank you very much. That was great. So now we have Dilara and Debbie representing Working Group 7. Dun, da, da, da.
I'm trying to share my screen. I hope I succeed. Can you see it?
Yes.
Yes, perfect. All right. Then with your permission, I will start. So good evening, good afternoon, everyone, wherever you are. So in this last session, we are going to discuss the topic of interactions between mediators and arbitrators who are appointed to the same dispute. This is what our working group has been looking into. I will provide a short overview of our work, and then I will pass the word to Deborah for the poll questions and actual consultation. So we focused on the scenarios where arbitrators and mediators who are not the same persons are appointed on the same dispute and wish to speak to one another and collaborate. And we found some examples, international examples, of rules and procedures that provide for the appointment of different neutrals as mediators and arbitrators. And these examples are simultaneous arbitration and mediation rules of a Chamber of Mediation and Arbitration of Paris, rules on MEDARP or ARBMED of the European Center for Dispute Resolution, and mediation rules of WIPO. And it's an interesting fact that while the number of such rules and procedures is rising, none seems to provide for the sharing of information between the mediators and arbitrators. Nor were we able to identify examples from practice where mediators and arbitrators worked together in the manner proposed by our working group. And actually, that's the first question and request to the audience. If you are aware of examples from practice or any rules providing for the communication and sharing of information between the mediators and arbitrators who are appointed to the same dispute, please do share with us. It would be extremely valuable for our work. But so far, in the absence of any rules and procedures or examples from practice, we based our work on discussions with the academics and practitioners, as well as on role-playing some of the scenarios. And here I would like to mention the members of our working group, and I would like to express gratitude to all of them who have contributed over the years to the paper that we presented at this consultation. Without these contributions, the paper would not have been possible. But going back to the manner of work of our working group, so we based our work on the discussions with academics and practitioners and role-playing different scenarios. This allowed us to formulate a framework that provides some guidance on how to combine mediation and arbitration in ways that would allow arbitrators and mediators to communicate in the interest of faster, less expensive dispute resolution and better outcomes as compared to the situation when mediation and arbitration progress independently. So in this presentation, this will be a very short presentation. I would just like to highlight the few key points in relation to our work that will hopefully serve as a basis for further discussion. And this would be factors to consider, possible scenarios, possible modes of communication, and then we will move on to the poll questions. So when arbitrators and mediators communicate, a central tension can arise because the rules of engagement between the arbitrator and parties on the one hand and between the mediator and parties on the other hand may differ starkly. Parties may perceive an arbitrator as an authoritative figure who renders a binding decision that may dramatically affect parties' business. At the same time, parties may perceive a mediator as a trusted person who respects confidences, who may or may not have an authority, who is guided by procedural principles and sometimes by substantive principles. And in general, mediators tend to be more flexible and they do not need to be as explicit as arbitrators. And rather than leaving the coordination of communication to chance or to the appreciation of different neutrals, the suggestion of our working group is that neutrals, parties, and counsel should first discuss what rules and principles exist. And particular attention should be paid to the procedural rules that apply to different processes, to mediation and arbitration, when deciding what and how the neutrals may communicate and who should take the lead. And here are the factors that we recommend considering when arbitrators and mediators come together and communicate. The risks of tainting the arbitration process and award, a strategy for managing those risks, an informed determination by all participants to proceed, well-documented consent, and well-defined contingency arrangements and risk mitigation structures and policies. And we identified 5 possible scenarios where communication between mediators and arbitrators may occur. Starting with the first one, it's structure development. So here parties wish the neutrals to help set procedural rules without deciding first who should lead, who between the neutrals should take the lead on communication. And this may result in a decision on which topics the arbitrator should take lead on and on which topics the mediator should take lead on. The next possible scenario is shadow arbitration. So here the parties want the mediator to take the lead and to involve the arbitrator only on key dispositive issues where a binding and evaluative input is needed. And this might be issues like findings of fact, determination of liability, quantum on specific points. The next scenario is shadow mediation. So here the parties want the arbitrator to take the lead and to involve the mediator on topics where the arbitrator, of which the arbitrator would not want to know, or of which the arbitrator would not want, or which the arbitrator would not want to consider. And the topics that the mediator may deal with is clarification of rules, or discussion of issues relating to witness testimony. The next process is a mosaic. And here parties wish the neutrals to take the lead through a series of sequential or parallel proceedings where greater emphasis is placed at different stages of the process as it evolves in time or on certain topics. And the last possible scenario identified by our working group is an integrated process. So here parties want the neutrals to sit together and consult with one another and with the parties at all stages, subject to some exceptions, like, for example, if the arbitrator's ability to issue a binding and enforceable award may be compromised if the arbitrator overhears what the information from caucuses. And so far, our working group has focused on 3 first scenarios. And in structure development, we actually looked to the work of working group 2, so the working group of Laura and Jeremy, for the issues to address. Structure development must be established early on in the proceedings by analyzing different procedural and substantive principles that parties and counsel think may or should apply. And if parties are unable to develop their own structure, they may rely on some central principles for both mediation and arbitration, like investigation of relevant facts, fairness of outcome and process, achievement of agreement or final outcome. In shadow arbitration, that's a process where the mediator takes the lead, and it may be useful for the mediator to first discuss any sensitive topics with parties and counsel to ensure that they know well what issues not to raise in the arbitrator's presence. And in consultation with parties and the arbitrator, the mediator can clarify and document any taboo topics that should not be raised in any joint meetings. Then parties may wish to identify key dispositive issues on which they would need the arbitrator's input, so that arbitrator should resolve. And this might be issues of causation, liability, and quantum. And it might be useful also to have safeguards in place so that arbitrator does not receive any information that may prejudice any binding findings of fact or law. And finally, I'm moving now to the shadow mediation scenario. So here it's the arbitrator who takes lead, and the arbitrator ensures that all procedural and substantive rules are addressed to achieve an enforceable and binding arbitral award. But they do not need to be necessarily appointed simultaneously. And it might be helpful for all participants of the process, for the parties, for the mediator, and for the arbitrator, that the arbitrator identifies areas that may or may not be discussed in the arbitrator's presence. Shadow arbitration should have free access to arbitration proceedings, partly to stay informed of what is happening in arbitration, so that there is no need to repeat the same information in mediation. And the first action of a mediator should be to facilitate discussions between the parties as to the role of a shadow mediator going forward, including those topics where rules do not apply, or where arbitrator does not want to dispose of, as well as the scope of a permitted communication between the arbitrator and the mediator. And finally, here, I would like to mention 4 possible modes of communication, regardless of the scenario. So this can apply to any of the 5 identified scenarios. Our recommendation is that parties and neutrals should select one of them. The first one is that the mediator and arbitrator are free to consult with one another without any advance notice to the parties. The second is that the mediator and the arbitrator are free to consult with one another without any advance notice to the parties, but only on specified topics or for a specific purpose. The third mode is that the mediator and arbitrator may consult only upon all party authorization in a given instance and possibly confined to a specific subject matter. And the final mode is that the mediator and the arbitrator are free to consult only in the presence of parties and counsel. So here in this presentation, I've mentioned only few key issues, but if you have a chance to have a look at our paper, you would find more details on each scenario, do's and don'ts, and qualifications for neutrals being considered for these assignments, and recommended default party agreements and practices for neutrals. And here I would be passing the word to Debbie for the poll questions. Thank you.
Okay, so Jeremy, are you going to put up the poll questions?
Where? Polls, and we are working group number 7.
There are 4 questions that we pose to everybody here, and again, as Jeremy and Laura admonished you, even if you don't know, please go ahead and answer. So the first question is, when embarking on a process where it is contemplated that a mediator and arbitrator will be appointed and communicate with each other, who should be appointed first? So in effect, what we're asking you is which of the scenarios that Dilyara pointed out should be the ones that are primary, or people would prefer. Should there be a shadow mediator? Should there be a shadow arbitrator, etc.? So please answer that. When embarking on a process where it is contemplated that a mediator and arbitrator will be appointed and communicate with each other, who should be appointed first? The next question is, once a mediator and arbitrator are appointed to a matter, who monitors and ensures compliance with the rules developed for the process? There's a basic understanding that when a mediator and arbitrator are appointed on the same matter, and they are going to be given the right to communicate with each other, somebody is going to have to ensure that a process that the parties might put in place for that communication needs to be monitored? Who is the one who should be monitoring that process? The third is, which scenario, as described in the draft paper, makes the most sense to allow for communication between a mediator and an arbitrator appointed to the same matter that would promote efficiency and effective processes. In this, I also ask you to think about, Gabor Farkas mentioned that if confidentiality is an overwhelming precept in these processes, now why should some things not be mentioned in front of a mediator or an arbitrator, especially if the arbitrator is not requested to, I guess what he means, render a binding decision. Well, one of the concerns that came up in our discussions was that mediators are, welcome all types of communication in the course of a mediation. If you have a shadow arbitrator, the arbitrator is probably given or made privy to information they wouldn't necessarily have as an arbitrator because they're shadowing the mediation. The reverse, if it's a shadow mediation where the arbitration is really going forward and the mediator is monitoring all of the proceedings, there's no confidential information that's being disclosed. So that was, that was a real concern. The fourth question is, in your view, how significant is the influence of legal culture of counsel and neutrals on the mode and extent of acceptable communication between a mediator and arbitrator appointed to the same matter? What we did see is that there are more acceptable modes of communication or modes of mediators and arbitrators that are appointed to the same case based on the culture. One of the examples that's described in the paper was in China, where a tribunal, arbitration tribunal, is appointed by the parties, and the chair asks, one of the questions the chair asks the parties is whether or not they want to mediate the case. If a party says yes, the tribunal of three actually changes hats and becomes mediators, but only one person serves the role of a mediator. The wings, so to say, stand and listen and see whether the case could be mediated. If the case does not mediate or does not resolve, then the parties revert back to arbitration. But that's an example where in China, at least, it's more acceptable to have that, that integrated role. Okay, so based on what I'm seeing, almost every 17, 18, 19 people have responded. I have to tell you, this is where we're going to ask everybody to chime in and give their views. We want to hear from you on this concept. When we did a lot of the role playing that we did to create the paper, those individuals who serve as arbitrators primarily were very, very uncomfortable with any communications between a mediator and an arbitrator appointed to the same case. They were very concerned that whatever information the arbitrator received from a mediator, that the arbitrator's thought process as well as decision-making may be tainted by the information that is provided by the mediator. And in addition, as I mentioned earlier in the day, that there are ethical considerations between the arbitrator and mediator, which might foreclose their ability to communicate some information. I also found out most recently, I should have known this, but in the United States, there's the Uniform Mediation Act. And in some states, in particular the state of Hawaii, when the Uniform Mediation Act was adopted, they basically have a provision that mediators and arbitrators who are appointed to the same case cannot communicate with each other. So the question that was raised by the person who called me was, how do we promote a process where there is communication between an arbitrator and a mediator in the face of a statute, if it was adopted in a particular state, that prohibits that particular communication. So, any reflection on this? What's interesting is, Jeremy, you think that we have enough people who answered 20?
Well, we have 20 of 29, so it's a 68% participation. So if any of you have not voted, please, in the next 2 minutes, if you can, because we really would like to share these preliminary results. So if you have not voted yet, please do so now. And while maybe you're doing that, can I maybe throw out a question to you, Diliara and Debbie, which goes to seat. There's with the Singapore Convention, the idea is the seat shouldn't matter anymore. And arbitration is the only area where the seat of the process matters. But if we're going to be looking more into the future of mixed modes, and the Hawaii example you just gave, Debbie, is a fantastic example, does that mean that you should avoid Hawaiian law and put in that the seat of the process will be some other state? How important do you think seat comes in this context also, if you have any views on it?
I think from my perspective that seat may not come into play if the case is ultimately resolved through the mediator portion. So you kind of avoid the problem with the seat. But if the parties anticipate that there might be a problem where that there has to be an adjudication through an arbitrator, then I think there has to be a lot more thought process up front about what the seat might be if arbitration proceeds. So that's a procedural issue. I think that has to be resolved in the beginning of the case, as if contemplating that arbitration is going to be how the case is resolved. Diliara, do you have a question on that and perspective on that? No?
I was going to ask a related question, Debbie. It's Kathleen. To me, what was going through the back of my mind through all of this is how much the question of enforceability of a potential arbitral award came into play in the discussions, because I think there are a couple issues, right? If I'm sitting as an arbitrator, I have to decide whether I would be biased, regardless of whether the award would be enforceable. And then in addition to that, I have an obligation as an arbitrator to issue an enforceable award. So if I think that, one of this like changing hats and like a lot of things, ultimately, I suspect a lot of it will be, if not shaped by, I would say at least influenced by the extent to which we're trying to issue enforceable arbitral awards. And I guess to the extent enforceability of a mediated settlement would be impacted the same. Was that something that you guys were sort of thinking about in the back of your minds, or is that what the arbitrators were concerned about?
I think that's for the most part was what the arbitrators were concerned about. From my perspective, maybe I was a little short-sighted, but the way I really saw a process where a mediator and an arbitrator are appointed to the same case was that it would lead with the mediation, and that the mediator would identify particular issues that were creating roadblocks in the arbitration proceeding, and work with the arbitrator on deciding those particular issues so that the mediation would end up being the vehicle that was the resolution that could be enforced under the Singapore Convention or some other mechanism. But I was really looking at it not in terms of the arbitrator issuing a final decision, but the arbitrator issuing all of these interim decisions, which would take discrete issues away from the parties and the mediator so that the mediation could end.
So it becomes kind of a form of evaluative, having many evaluations within a mediation by an independent. I think it's very interesting. I think the issues of enforcing the ultimate award by an arbitrator, in other words, if you fail and then the arbitrator has to put back on his or her neutral hat, I think that could be problematic, would be my bet.
If I may add, so if we are discussing the possibility of the exchange of information between exchange of some information between the mediator and the arbitrator, I think the issue becomes very similar to the situation when, well, perhaps not very similar, but quite similar to the situation when the arbitrator acts as a mediator and then goes back to the arbitrator's role. So the issue of bias of the arbitrator and of breach of due process to some extent would also arise in the context of exchange of information between the mediator and the arbitrator, who are different persons. And that's why one of the suggestions of our working group is when the arbitrator does receive some information from the mediator that he might take into account when rendering a decision, he cannot do that unless he allows parties to provide their input on this issue.
And I suspect there would be a lot of consents involved.
Of course.
Consent to this, consent before, consent after, all that, yeah.
Absolutely, and that's the same. I see it as as a process that is that raises very similar concerns to the ones that arise in the context of the same neutral acting as a mediator and arbitrator.
Exactly. Interesting.
So let's go to the results that we had, because we have 78% of the people who are attending actually participated in the poll. So basically, it's interesting. There's close to even divide. Most people think that the mediator should be appointed first, while others think that both the mediator and arbitrator should be appointed simultaneously. Query, and this is another issue that we discussed in the working group. If both the mediator and arbitrator are appointed simultaneously, should both the mediator and arbitrator, as well as the parties, be involved in crafting and designing how the communication, what should be communicated, and how the communications should transpire on a going forward basis? And I think the consensus basically was, if they were appointed simultaneously, that everybody it should be a transparent process where everybody was involved in those discussions. There was also a lot of discussion that the discussions should be limited to communications about process and not substance. So the second one, once a mediator and arbitrator are appointed to the matter, who monitors and ensures compliance with the rules developed for the process? And most of you answered the ADR provider organization, whereas the next selected answer was the mediator. What I find interesting in this answer is that most mediation is ad hoc. It's not done under the auspices of an ADR provider organization. So by saying the ADR provider organization, are we really saying that it's going to be the arbitration provider organization that monitors the processes that were put in place and the compliance of those processes? Anybody have a thought on that?
I also find the answer interesting to this question because, I mean, I would answer actually differently depending on whether it's an arbitration and a mediation. And of course, confidentiality plays in a lot more in a mediation. And yes, and certainly, yes, there's a lot more ad hoc and, for example, court-related mediations in Europe. So yeah, the answer would definitely be different.
Okay, the third is, which scenario, as described in the draft paper, makes the most sense to allow for communication between the mediator and arbitrator appointed to the same matter? Most of you, or the majority of you, said an integrated process with structured development as the second, which, you know, really leads me to really believe that most of you probably think that the communication should be limited to process and procedure and not necessarily to the substance of the case. I think by limiting the communication to process and procedure, basically what you're doing is avoiding the ethical issues and maybe ultimately the enforceability issues that we discussed. Okay, in your view, how significant is the influence of legal culture of counsel and neutrals on the mode and extent of acceptable communications between the mediator and arbitrator appointed to the same matter? And most of you think it's significant, whether it's very or somewhat significant. You know, one of the things that I reflected on when we began this process was that it was still unheard of or very infrequently where a mediator or an arbitrator changed their hats and changed roles. In fact, there was a prejudice against the same person changing their role in the midst of a proceeding or working with parties. Today, maybe it's because people have become much more confident in the types of disclosures that they receive beforehand. They just are more accepting of mediators and arbitrators serving in different roles on the same matter with the disclosures. But I also think that if you look at the number of providers or organizations that have adopted rules throughout the world, and you look at the paper that we developed, most of them are outside of the United States and outside of Europe. So it seems that there is a much more flexibility for people who are in Asian or other cultures and not Western or common law oriented countries.
I had one question because, you know, I'm in working group 4, and among others, and one thing that we see also in the ICC context is we see a lot of movement towards the inclusion of mediation windows in arbitration schedules, so that, you know, arbitrators are being very strongly encouraged, as you know, when you said, to suggest a mediation window, right? And so you have a mediation window, and I think one of the questions that will arise is, well, can the mediator ask the arbitrator questions about the arbitration that might be helpful to reaching settlement without risking the award? Is there any way to do that? If so, how? So I think that, you know, if we move towards mediation windows, I suspect we're just not going to do it out of caution for the award. But I think it's an interesting question posed by your working group.
Well, it is an interesting question, and, you know, keeping in mind that arbitrator deliberations are always confidential. Basically, what this mediator is asking is for, the underlying rationale or disclosure of those deliberations to help the mediator. And that would, if I were to anticipate posing that question to the group, the people who mostly arbitrate would be very uncomfortable, very, very uncomfortable disclosing that information and would resist.
I think we need to also remember where that was in a context of primarily Anglo-Saxon common lawyer arbitrators. Chinese arbitrators might see this very different from mainland China or in other places. So I think we do have to bear that in mind. But if I can go back, Kathleen, to your own question there about mediation windows and how this works out, how do you see it? Let's just take an investor state case. And let's say that you have this cooling off period early on, and you know that there's already a dispute on allegations of national sovereignty or issues of public policy where they say it's a matter of national security that some evidence not be heard. Now, there is the tendency for the arbitral tribunal to kind of get involved in deciding, what should we be receiving or not as evidence? How do we do this? And then they got to kind of maybe discount it. Isn't that a perfect topic, though, for mediation and a perfect time for mediation? Not just, I would say, to focus on those issues, but even to go back and now rediscuss whole option of process design. Because in the very few cases I've been able to get involved in investor state cases, I find that there's never been a proper ability to discuss this because the tribunal is too afraid of looking partial by coming in too early with any views on this. They don't know how to handle it, and they won't even recommend speaking to a mediator because they feel it's not their role to do so. And that's inappropriate for them in a way to suggest that another neutral be brought in. So what are your own views on how do you, those sorts of topics and issues that we know come up quite often in certain very big complex disputes?
My own personal view, for what it's worth, is that what we heard from in-house counsel very strongly, some from states, but primarily from commercial entities, was that if an arbitrator is going to suggest a mediation window, they should do it at the first case management conference. Because at that point, the case hasn't started. So at that moment, you can schedule it in. But if when we sit as arbitrators, all of a sudden we say, have you guys thought about mediating that? It's a signal. The parties then go off and spend way too much time trying to read the tea leaves, and that would typically not be helpful. But I think the idea of suggesting and even encouraging mediation windows at appropriate points in the process at the case management conference, that, I haven't even gotten a lot of pushback from the most arbitrator-like arbitrators. Because I think there is this movement towards, if you want to call it mixed mode, towards, trying to have parallel proceedings where appropriate. And sometimes there's a mediator waiting in the wings because you had an unsuccessful mediation as a step. So, there's all kinds of swings and roundabouts. But I think this issue of, Debbie, I don't think obviously deliberations would be off the table, but usually at that point you won't have had many deliberations. It's really more like, so what do you see the real issues in the case being from the mediator to the arbitrator, that kind of thing. But even that, I think I would be very uncomfortable doing, but I think it's interesting, very interesting.
I think based, my recollection of the arbitrator training that I had was we were told not even to do that.
Yeah, of course, yeah.
So, Laura, did you want?
Yeah, I just will say that almost all of the providers now encourage you to say something at the beginning about the availability of mediation during an arbitration. And I think there's some confusion about this window concept, mediation window. because you can have mediation in parallel throughout the whole proceeding. What does the window mean? Does it mean you're suspending the arbitration for that time? Does it mean a pressured time when they're supposed to attend to it? What is the meaning of the word window?
I think it's more in a lot of cases, it's really to encourage the parties to, sit down at that moment, whether it's a mediation, whether it's a negotiation. It's a time that the parties have agreed going in before they started to really hate each other, that it would be an appropriate moment to sit down again. And at that, they may not have to stay long, but they've agreed that they will mediate at that moment. So I think so obviously it doesn't prevent parallel mediation. That would be even better. But in many cases, there hasn't been a mediation, or the mediation has really failed. And so the parties aren't talking anymore. So I think the idea is to have a trigger. It's a trigger, really.
And my video is off, but let me just comment, because in cases I'm currently handling, in the first pre-hearing conference, I talk about why they should retain a mediator. And it is not just to settle the case. The mediator can be very helpful in making the arbitration more efficient.
Yeah. Totally.
So in reducing expense and reducing time. So I get very little resistance, but I make it very clear that you have to decide when and if you ever want to settle this case. I'm saying get a mediator as a process facilitator for the arbitration.
Would you talk to the mediator after he or she was appointed, Paul?
No, I will not talk to the mediator. I don't want to hear any more about it. Though let me tell you that when they report to me, we haven't yet retained the mediator, I do remind them about the suggestion and how practical it was, regardless of whether or not they were ready to settle the case.
So, one of JAMS has this rule where they call it they have a standby mediator who is appointed at the same time as the arbitrators are appointed. Well, I thought that it could really go one step further. Under the JAMS rule, the mediator doesn't do anything; they're just on standby. But what if that mediator sat in the arbitration proceedings as an observer? Not necessarily discussing the case with the arbitrators, but just sat in and observed and touched base with the parties every now and again about, do you think it's time to settle? Do have you heard enough that you have an opportunity to put a dollar amount on this and you want to settle? And, I think that might be, a process that the parties could live with.
I don't think so. Yeah, if I were one of the attorneys in a situation like that, unless I really knew who the mediator was, that I'd be worried that the mediator, would frown and compliment. He would, with his body motion and things like that, would do things, and I tell the other side, hey. You thought I had a lousy case. Well, the mediator seems to think that I have a good case. So I'd be very careful about using a mediator like that.
You yourself put the qualifier on that. You said, unless I knew who the mediator was. So you really did open up the.
But the other issue is just a straight cost issue. That clearly increases the cost of the process, which I think is not something, if we're going to introduce these concepts, we have to be introducing them as cost effective or cost saving and efficiency saving. And I'm just concerned that adding another, especially a very expensive person onto the list of time would be very ill received by outside
if I may, if we compare this process where where there are two neutrals instead of one neutral acting as a mediating arbitrator, we will see that the process, yes, indeed, it's more expensive because you have to pay two neutrals. But if we compare the process that we are talking about, where there is some interaction between mediators and arbitrators, so there is certain overlap, these processes can still be more time efficient, at least compared to the processes where mediation and arbitration are conducted independently and they do not overlap. So, of course, here the question remains for the parties to choose if they prefer to have two neutrals, and if they prefer that there is an overlap of processes and there is some exchange of information, then, well, it's up to the parties to proceed in this way. Anyway, this process would be still more time efficient as compared to the process where the mediation and arbitration are conducted separately and independently.
And the way I would handle it in the report ultimately is that cost considerations are always paramount to the parties, but that there's the potential that it either could cost less or it could cost more, depending on how the parties formulate it. So we're actually 3 minutes after the time we were supposed to close. Thank you, everybody, for participating. As everybody has said previously, please don't have this end the feedback. Provide feedback to us. Send it to Ivana at IMI, and we will be happy to incorporate that feedback into our final report, which would be the 2021 version of the task force report. It's been a long day. You've been participating and listening, and thank you very, very much. Ivana, do you want to say anything in closing?
Yes, thank you everyone for the wonderful contributions to these really cutting edge issues. It was a very interesting discussion to listen to. So tomorrow we will be resuming at 11 a.m. EST and 5 p.m. Central European Time with Working Group 1, and then moving on to Working Group 4, arbitrator techniques and their effect on settlement, and then Working Group 6, finality and enforceability of facilitated and arbitrated mixed mode outcomes. After that will be the discussion of the whole work of the task force. So we hope to see you there.
Okay, thank you very much and have a great day. Goodbye.
Thank you. Thank you. Ivana, great job. Thanks, everybody.
Yes,
Thank you.
Ivana, thank you.
Thank you, everyone.
Bye-bye.
Bye.